for 2 weeks, but 2 weeks has gone.
What matter?
Matter relates to criminal, my lord. Bail matter, my lord. Case diary is available.
Yes.
Highly, my lord.
May I please, your lordship? My lord, criminal matter supposed to come on Friday, my lord. Fixed matter, my lord. Let it be come on
Single bench.
single bench, my lord. Criminal petition, my lord.
Why don't you mention before the regular bench?
My lord,
This is not a regular bench. This is only for today.
it is supposed to mention before this honorable court.
All right.
I beg to mention item number 37, my lord. CD, I have inquired, CD is not available, my lord. Case diary is not available here, my lord.
37, what do you want?
Adjournment, my lord.
On the prayer of Mr. R.S. Mistral and counsel for the applicant, this matter stands adjourned for
1 week, my lord.
a week. Yes.
There is an interim order, my lord.
Where is the PP? The case diary is not available.
Lordship, proceed.
Interim order passed earlier to continue.
Oblige, your lordship.
Wait, please, your lordship. I beg to mention item number 7 of the daily list. This matter will be adjourned for the day, your lordship.
Item 7, as prayed for by petitioner's counsel, passed over for the day.
Deeply obliged, lordship.
Your lordship, I beg to mention item number 48 on the daily list.
Yes.
I'm the counsel for the respondent in the company petition, and with the consent of the opposing counsel, we pray for an adjournment. Your lordship, the settlement offer is still under consideration, and we've been regularly following up with the bank.
Who is for the other side?
I'm not appearing in this.
I've obtained consent of Mr. Mukesh Sharma, counsel for HDFC Bank, your lordship.
You are for whom? Applicant?
For Jalannagar Development Private Limited, the applicant, and for Chota Tingai
With
TSA.
the consent of the opposite party, Miss, your name, please.
Maitrey Das.
Miss M. Das, counsel appearing for the applicant, seeks adjournment in this case for further 4 weeks on the ground that the talks of amicable settlement by and between the parties is still going on, and the same is at an advanced stage. In taking note of the submission of Miss Das, this matter stands adjourned for 2 weeks. 4 weeks. 4 weeks. Yes.
Yes, lordship. I'd like to mention for listing of a IA in a criminal petition, lordship. What happened in this case, lordship, this honorable court granted stay, and the lower court is proceeding with the case. And now, in fact, bailable warrant of Rs 2,000 was issued against the accused. There is a stay order against in this case.
Why you have not produced the order?
Yes, I have produced the order. In fact, if your lordship peruse the entire case record of the lower court, it will shock the conscience of this court, because a magistrate came in the trial court. He recalled the first NBW PNA was issued, and then I submitted the order copy, certified copy of this court, and then that PNA was recalled, and then another.
Which court? Who is the magistrate?
CJM Defu, lordship.
CJM Defu.
Yes, lordship. Now, when there is stay, lordship, and the learned court below is passed an order that saying that there is stay order is against only one accused, and the other accused there is no stay order. Therefore, in respect of other accused also, it is proceeding.
So what do you want?
Lordship, listing by today itself, lordship, at 2.
Today itself not possible. You have it, you give the listing. Today not possible. No
Tomorrow,
unlisted.
Tomorrow, lordship.
Day after tomorrow. Yes.
Obliged,
Yes.
Two revision petitions are filed. They may be listed tomorrow, your lordship.
Sorry?
2 revision petitions are filed, analogous matters, because the lower court matter was fixed on day after tomorrow at Dhubri. So the matter may be listed tomorrow.
All right, you give it.
May it please your lordship, I'm praying for listing of anticipatory bail application, lordship, for bail hearing, lordship, on 14th. Obliged. May I please your lordship, item number 30, my lord, kindly matter may be adjourned for the day.
Item number 30, 30.
30, my lord, due to some personal difficulty, my lord. Maybe
On the
fix
ground
on
of personal
witness-
difficulty of the applicant's counsel and on the prayer of Miss
Al-Islam.
Al Islam, learned counsel for the applicant, this matter stands passed over for the day.
Lordship,
Item 30.
CD is available. Maybe fix on Wednesday or Thursday, my lord.
List again on Wednesday.
Lordship.
Ah.
My lord, one more matter, item number 33, my lord, same matter may be adjourned for the day. 33 item.
33 also same prayer. Fixed on
Interim may be continued, my lord.
list again on Wednesday 14. Interim order passed earlier to continue till then.
Highly obeyed.
May I pray for listing of an appeal for orders, ma'am? On 15th, ma'am.
What order you want?
Ma'am, I have to include the informant, ma'am, POCSO appeal, ma'am.
Hmm.
Because of the confusion that whether I have to make the informant party or it was not met, possibly it is required
It
now.
is a single bench matter.
Mine,
You have it on 17th.
mine.
Not 17th, 16th.
Well, it's bail application, my lord. The accused killed crane by air gun, my lord. And he was
Where is
arrested.
the FIR? Where is the adjournment?
FIR, my lord. That copy, lordships, and we perused.
Page number?
Page number 10.
Wildlife matter.
Yes,
Wildlife.
wildlife, please.
So we have to call for this
Yes,
Yes, Your Lordship.
CD or report?
For the offense report, Your Lordship. Offense report.
Offense.
When can you produce it?
After a week, Your Lordship.
All right. Heard Ms. Sonsuke, legal and counsel for the applicant. Also heard Mr. R.R. Gogoi, and a special PP, WP, WF. No, Wildlife
Wildlife
Protection Act,
protection.
who prays for a week's time to produce the offense report. Prayer allowed. List this matter again in the next week.
18th.
That is not 18th, it will be 18th is a Sunday, perhaps.
Monday,
19th.
18th is Monday,
yes.
19th is Monday.
19th.
Oh, 19.
19, 12, 2022 for production of offense report
Yes,
by the
yes.
learned special PP. Yes.
Lordship.
Yeah,
Our name may be reflected in the cause list, Your Lordship.
His
Let
name
the
is-
matter be listed again by reflecting the name of Mr. R.R. Gogoi in the cause list.
Highly obliged, Lord.
Yes, which section?
21C and 29, commercial quantity. Your Lordship.
How
Yes.
much time?
2 weeks, your lordship.
What will it be? LC, this case diary or
His diary.
case diary? 2 weeks. 2 weeks, but it will be vacation.
Maybe in the month of January, Your Lordship.
All right. Heard Mr. T. Devery, learned counsel for the applicant. Call for the case diary. Fixing. 3rd January, 3rd January,
Yes.
2023. Report given
Third
with
January.
India learned APP, senior counsel in APP Assam, assisted by Ms. M. Chakravarti,
M. Chakra.
is present on behalf of the state. Call for the CD, fixing so and so.
I'm deeply obliged.
Which section?
My lord, is section 121A, 121, my lord, and section 17, 19, 20, 21, 39, 40 of the Unlawful Activities Act, my lord.
Hmm.
And she was FIR, my lord. That I ran the my lord, he's the Imam of the Madrasa petitioner, nowhere in the picture. One person arrested, saying
But
that,
UAP Act, the PP must get a chance to,
yes, my lord, today 121 days, because why, my lord? My lord, mandatory period is over. Thereafter, on 26/10/2021.
this is the first time you have approached the
Yeah,
court.
first time.
Lordship, his diary be called for.
Yes, my lord.
When?
Lordship, before the vacation. On
Can you do it before vacation, 21st? 21st
Yes,
December?
ma'am.
All right, you write Mr. FKR Ahmed, Baki Pini, okay, 21st December.
Because my lord, only after being arrested, I come to know that I have committed such crime, my lord.
What is?
May I please, Your Lordship.
Yes,
Allegation under section 354,
354.
reading section 10 of POCSO.
Hmm.
It is beyond the bar for 33 days. My lord.
Lordship, his diary.
Yes, you're Mr.
M. Kolita.
M. Kolita, or Baki Pini, okay, when?
March, January.
No,
3rd January?
no, today is 33 days. And kindly peruse the learned court below's order dated 30,
So
11.
let us see what is the, where is the, let's see, yes.
Lordship, FIR is here, page 14, my lord.
Hmm.
FIR lost under section 25(1)A and 27 of Arms Act, my lord.
Hmm.
CD may be called for, my lord.
Which place, which place?
South Salman.
South Salman.
When, before vacation?
Before vacation, kiman din ase?
Today is 51 days.
22nd, 22nd.
22nd?
Lordship.
Yes. नाम तो दीजिए मिस्टर एस दत्त बाकी हिंदी दी 22nd.
Item 6.
सब सीडी है सीडी कोई.
May it please your lordship.
Yes.
The petitioner is in custody for 31 days, lordship.
Hmm.
And the FIR says that under section 120B, 379, 411, 34 of IPC read with section 23 of Petroleum Act. FIR is at page number 13,
Page number 13.
lordship.
So you
21st, your lordship, for CD.
21st for CD. Miss M Das 21st CD.
Obliged.
बाकी है नाम तो दीजिए.
Item 8.
May I please, your lordship, my lord, allegation under 22C, lordship. My lord, as on today, I am 60 days in custody and I am entitled for default bill, lordship. As on today, 60 days, lordship.
Lordship,
22C.
Yes,
NDPS.
22B, lordship.
22B.
Yes,
What is it?
lordship, case diary be called for, your lordship. It's from.
already 60 days as on today, lordship.
Day after tomorrow, you give us a report, whatever you want to do it.
Yes.
Day after tomorrow.
Obliged.
Day after tomorrow. Mr. M.I. Hussain, learned counsel for the applicant, who submits that his client is in jail since last
60 days.
60 days and therefore is entitled to default bill. Full stop. Miss B. Bhuya, learned senior counsel and APP Assam, assisted by so-and-so. However, submits that she be given time till 14/12/2022 to call for the CD and obligor obtain instruction in the matter. Stop. Prayer allowed. Registry to list this case on 14/12/2022 as a fixed time.
Obliged, lordship.
Item 9.
Lordship, under section 21B, the woman was arrested on 30th of July and search sheet already filed at page number 20.
Charge sheet already filed.
Filed. My bail
Then
application was,
you-
my bail application was rejected by the trial court on 26/10/2022 and thereafter also 11 of October, November 2022.
Then we'll have to call for the scan copy of LCR, is it not?
My humble period is a woman and she is a minor child which is suffering from various diseases.
We'll fix it immediately on reopening.
Can you?
We have to have a look at, we can't grant you
Yes.
bail without the record. You see,
Yes.
please understand.
Prior to vacation, 21st.
Yes.
Obliged.
You write Mr. DK Bordole, you're DK Bordole,
Yes,
right? Like counsel for the applicant, so and so for the state. Mr. Bordole submits that his client has been in jail since
Till 30th of July.
30th
30th
of July 2022,
Yes.
and his minor child,
Minor child is suffering from various diseases.
and it's a lady,
Yes,
and her minor child is
Yes.
suffering from various critical ailments. First up, in view of the urgency expressed by the applicant's counsel, scanned copy of the LCR be called for. Let this matter be listed again on 22/12, not 21/12, 2022 as a fixed item, registered to issue immediate requisition for the scanned copy of LCR.
I don't know.
Supplementary list, item 51.
51 and 52 same category and my lord, similarly, my lord, the co-accused, my lord, already granted bail, my lord, on 9/12, my lord. What has to do?
Co-accused granted bail without the case diary.
Yes, my lord, without the category.
But you have no copy too.
I don't know. Very fast.
Where is the CD? Where is the FIR?
Affair is page 8, my lord. Page 10, my lord. Okay, relevant.
Yes, what do you say?
Lordship. Lordship, they were asked to produce the document, your lordship, they could not do so. Their name is specifically in the FIR, my lord.
So
These two
what is the
persons.
need for custodial interrogation in this
Lordship,
case?
let the CD come short date be given on Friday.
No, co-accused has already been
Whether
granted.
it was after perusal of the case diary, the order doesn't reveal so, your lordship.
Very motion day, my very
Doesn't reflect it.
filed on 4/4/12. 6/12 filed and 7/12 registration and 9/12 granted. For
Who was the counsel here?
my lord.
Was the case diary called for?
No, my lord. NK Kolita, my lord. Very fast granted bail, my lord. I want six.
No, what is the allegation? Cattle was being taken, which they believe will be smuggled to Bangladesh. That's all. Ownership
Yes.
of the cattle is there. So what?
But they
what-
could not produce, if they are owners of the lordship, the cattle,
Hmm.
they should have produced the documents, which they could not, did not produce, my lord, as per the case, the lordship
So
FIR.
how come 120B and all these things are added here?
Lordship, day after tomorrow then, lordship. I'll talk with Miss SB Bora, whether it was after perusal of the case diary
And a
or.
very motion day, my lord. A very motion day, my lord. 7/6/12 file, my lord. 7/12 registration, my lord. And 9/12 granted bail, my lord. As per website of the High Court. Kindly check the website. Very fast.
But it's written
I
after
was present that
perusal of
time, I thought.
records, whether after perusal of the case diary, that is not written.
Kindly see.
You find out, we'll take it up after
Yes,
some time.
yes.
After some time.
Yes, publish.
Motion over. For admission, Margaret letter, I can tell. Wednesday. Oh, sorry, sir.
Well, in this batch of cases, my lord, the deputy commissioner had, I had talked, my lord, they have prepared a report. No, they are sending me the report, my lord. Kindly give me some time, my lord, so that I can produce the report, my lord. Or,
What report?
but here. I have not received the report yet. They are in the process of sending it.
In fact, yesterday we were
Lordship.
called for a meeting, my lord,
Lordship.
and that meeting, my lord, was to discuss, my lord, the construction of the building, my lord. Nothing of that sort, my lord. So for the land is concerned, my lord, verbally they told that, my lord, they'll be giving us some land near the river, my lord, which we have already earlier refused, my lord. Because, my lord, it's, my lord, erosion, my lord, prone land, my lord. My lord, if they want to give a land, my lord, let them come with some equivalent land, my lord. They cannot just give anything and whatever they feel like, my lord. They are just playing, my lord. They're not at all interested, my lord, in settling the issue, my lord.
But I have not received the report. Let me-
Mr. Nath, you see, this matter is in the court now. The court has made some observations prima facie.
Lordship.
Now, if you wish to sort it out, it is up to you.
Follow.
We have nothing against the school.
Lordship.
But if a litigant raises a legal question, we will answer it legally.
No problem.
And unless or subject to what you may say,
No problem.
if an order comes setting aside the whole development and a direction to revert the land back to them, then what will happen is you have to either get the order reversed in a higher forum, which is a matter of chance,
No problem.
or the whole thing goes.
No problem.
So
Well, here, but I am basically praying, but since ultimately it's a college, it is in the interest of the local public also, but they are
so
also.
therefore, why don't you sort it out with them?
But-
You have to give them land, otherwise we'll interfere with it, as simple as that.
True, true, true,
There's no other option.
true,
You can't take away somebody's land without following the due process of law.
but right,
So because it is school, therefore we are giving you a long rope.
logic.
But if you play around with the court, if you means your clients, then it's not going to be of any
No,
use.
but,
A day will come when we'll deliver a judgment. That
but,
day is not very far off.
the communications are with from the higher authority, from the department also to the.
That
DC.
is correct.
And the-
What I am saying is,
And what is
if
the
the
outcome?
idea is just to produce some report here, something there, and then delay the matter and then say that it is a school building, etc.,
No,
etc.
they have an intention. to
Or
settle
else
it,
you pay them compensation, as simple as that.
But
Even now you can acquire the land and pay them compensation.
that option is there, but whether under this particular project, amount for compensation, payment of compensation is there or not, I'm not. aware,
That
no?
is your internal matter.
True.
Hmm.
True. Let the report come, up. Give me time till tomorrow.
We'll deliver the judgment on 5th of January. Whatever report you have to place, bring it on record by 3rd January. And after that, we'll proceed and pass a judgment. Whichever way it goes, it goes.
Or,
Mr. Nath,
but I'm not.
see, these things have to come to a close.
True.
It can't go on dragging. Eh?
No, but we are not.
Whatever your decision, you take it. Then we will take our decision. But of course, the court is conscious that there is a educational institution, there is some public interest involved.
And one of
That
the,
is the reason we are going slow on the matter.
some amount of public money has already been invested in the project.
That is the reason.
Gotcha.
But then if you say that, sorry, whatever the law says, we don't care. We have
No,
done this.
No,
Then
I
what
can't-
option we have? We have to
I can't.
put our judgments in place.
No, I can't say that.
Then
Say that.
what you tell us?
Just
Either
they
you
have-
justify,
They
you
are,
have taken their land without paying any
they are
compensation.
trying to sort it out, no? They are trying to sort it out, and I'm just
So
waiting.
what is the option for the court? You tell me. Can the court look the other way if somebody says
No,
law has been violated?
Court has no. Court
Then-
cannot, court cannot. No, we have sought for time so that we can settle it out outside the court. No. If it is agreeable to the petitioners.
Heard Mr. M. Datta, Learned Counsel appearing for the petitioners, also heard Mr. D. Nath, Learned Senior Government Advocate Assam, who submits that hectic efforts are going on to resolve the contentious issue involved in this proceeding. And therefore, 4 weeks further time they granted for arriving at a settlement in the matter. Full stop. Mr. S. Nath, Learned Counsel is present for, you are there?
Yeah.
S. Bhuya, you are for?
That's 112.
Respond number 2. Mr. Dekar for respond number 8. And Mr. J. Handy, what is the respondent number?
1.
তো খোদাই লব এখানে are present. Full stop. On the request of Learned Counsel, Learned Senior Government Advocate Assam, these matters are directed to be posted again on 9th of January, 9th of January 2023 as fixed items. Full stop. The official respondents to bring their stand on record on or before 5th of January 2023
Diplomat.
by furnishing advance copy upon the petitioner's counsel.
Diplomat.
With the lordship, my lord, in this matter on last occasion, it was submitted, then first it was filed, my lord.
Hmm.
But
Yes,
in the order, it was not reflected last time by mistake, but
Yeah, Mr. Das, charge sheet has been filed, submitted.
Yes, CS number 49/22.
49/22.
22.
This is which
Dated
police case station?
police station. Doboka.
So then you,
Doboka zone.
uh, take down, heard Mr.
Sorry, Milo, this is Jamuna Mukhi.
Jamunamukh PS.
Yes,
Take Heard Mr. D.P. Bora, learned counsel appearing for the applicant. Also heard Mr.
Date
D.
is
Das.
30 September. 30 dated.
Also heard Mr. D. Das, learned APP Assam appearing for the state who submits that the charge sheet bearing number 49/2022 dated 30th of September 2022 has been submitted in connection with Jamunamukh PS case number 53/2022 poster. Situated thus, the applicant's counsel seeks leave of this court to withdraw this application and approach the learned trial court seeking regular bail. Prayer allowed with liberty as paid for.
Obligation.
Bail application stands disposed of. Yes.
Item 16.
May I please your lordship, 150 days behind the bar, lordship. And this is the succeeded case, lordship. And the earlier dated is a lordship CD. Scan copy.
150
days.
Lordship, scan copy was called for, Lordship, and I have perused the scan copy. Lordship will find it as scan copy, there is a judgment, Lordship. Now let me verify whether this accused has been, I have seen the judgment, he has been already acquitted from the trial court, by the trial court.
Let us see. What is the name of the accused?
His name is Amser Ali, Lordship. Two witness examined, Lordship, on the statement of the evidence of the victim, Lordship, PW2. The trial court has acquitted. I flag mark the judgment, Lordship.
You are not aware? Dr. PSK 59.
The judgment passed on 13/9, Lordship, long day.
You are not in touch with your client. Find out and tell us in 11:30, you give me the information. We'll close it. Have a look at this, call up your client and tell us. Call it at 11:30. Mr. Borua, please come at 11:30.
My lord.
What is your name? You have understood?
Yes, lordship.
15 minutes, you find out whether your client has been acquitted.
Yes.
We'll close this matter.
Yes, your lordship.
Item 17.
This is for an application matter. Under section 22C matter. Today is 13 days matter. Charge sheeted case matter.
How much? What is the contraband?
1500 syrup, my lord. Codeine
Cough syrup.
cough syrup, my lord.
1500 bottles of cough syrup, it's a commercial quantity, Lordship. And there is, Lordship, 7 witnesses in the search sheet. Out of 7 witnesses, only 1 witness examined, Lordship. PW1, he is the informant. He was examined on 31/10/2022. And the next date is 14/11/2022 for further evidence, Lordship. And it is the contraband, Lordship, this 1500 bottles is from both the possession of both the accused person, Lordship. The commercial quantity records of 37 is there, Lordship.
Which place is this?
Karimganj.
Dhubri, Lordship. Dhubri to Karimganj.
And where is the order of the trial court?
The page
Rejecting your bail?
page 31. That's it.
So, Mr. Bora, where is the scope for granting bail now?
I'm the driver and handyman only.
Maybe, but then 1500 bottles of cough syrup business.
But it's a commercial quantity, Lordship. You already PW1 examined, Lordship, other witnesses yet to be examined.
Now, what is there? The LCR has been called for.
Yes, yes.
It's called scan copy.
Yes.
Where is it?
but it is along with the main record, Lordship.
Give me the ulcer. Not now.
That's it.
Heard Mr. D. Bora and counsel appearing for the applicants. Also heard Mr. R. Burwal and special yours.
No, my lord, it is only people.
Additional PPSM appearing for this state. By filing you write like this, the applicants herein were arrested on
13/5.
13/5/2022 in connection with Golokganj PS case number 170/2022. And since then they are in jail. 170/2022 registered under section 22(c) of the NDPS Act, 1985. And since then they are in jail. The case has already been charge sheeted and the trial has also begun. I perused the case, scan copy of the case diary, which goes to show that only one witness, namely PW1, has been examined so far. Full stop. After going through the testimony of PW1, this court is of the opinion that present is not a fit case for enlarging the applicants on bail at this stage of the trial. As such, the prayer stands rejected. Make it at this stage. Let the witnesses be examined and then we'll see.
Yes.
Bail application stands dismissed.
Item 18.
Next, Mr. Lordship.
Yes.
Bail application, Lordship. This company was called for, the trial is going on. Petitioner is behind the bar for 131 days, Lordship. FIR page 13, Lordship.
FIR page 13.
Yes, Lordship.
Yes.
I have annexed the medical report, Lordship, annexer 5, Lordship, page 24, Lordship. 11 portion, page 25, Lordship, serial number 11. Date of examination, Lordship, 3/8/22, time 2 AM, Lordship. Next, lordship 26, page number 26, lordship, serial number 16, lordship. Genital examination, lordship, genital organs, vulva, hymen.
May I please, Lord? My lord, I am on behalf of Mr. A. Ali, my lord.
Hmm.
My lord, this is subsided matter, my lord. My lord, commercial quantity, 4,997 bottles recovered, madam. Charges has been framed on 25/7/22, not yet any witnesses.
Only 4,009.
My lord,
You didn't say only. Yes.
my lord, no witnesses examined till date, my lord. Charges has been framed on, my lord, 25/7/22, my lord. So, my lord, my father condition is serious, my lord.
Hmm.
So I am the only breadwinner of my family, my lord. Has any condition so
That's
far?
correct, but what to do? Only 4,900 bottles.
Commercial quantity, my lord.
Hmm.
Last date was fixed on 22nd November for recording of evidence. And then what even lordship?
My lord, next date is 1912 for evidence, my lord. 19/12/22, my lord. Let us, my lord, wait a few days, my lord. After 19, my lord. Any date.
You don't want to press your father's ground.
No, my lord. Let us examine the informant, witness. What's the material?
So we'll adjourn it.
my
If we done, heard Mr. You are not,
No, my lord. I am on behalf of Mr. A. Ali, my lord.
whose name to be recorded?
A. Ali, A. Paramedic. I am A. Paramedic.
That I know, but whose name should be recorded in the?
A. Ali, my lord.
Heard Mr. A. Ali, learned counsel for the applicant, also heard Mr. S.C. Kyle, learned standing counsel, NCB, appearing for the respondent. Full stop. After hearing the submissions of the parties, it appears that next date for recording of evidence of the
1912.
prosecution witnesses
19/12/22. Next date.
is fixed on 19/12/2022. Full stop. Considering the ground on which bail is being sought, this court would not be inclined to examine the same unless the evidence of the informant, at least the
My lord.
informant, is recorded by the learned trial. Full stop. In view of the above, let this matter be listed again immediately on reopening of winter vacation. The applicant's counsel may place on record the testimony of the informant if the same is recorded in the meantime.
Hello.
Time being letter item 16.
Yes,
Yes, lordship, I informed lordship, did not receive my informed lordship. I will inform lordship. Did not receive my.
all right. Where is the judgment copy? Your name, please?
M.A. Mondal.
Mr. M.A. Mondal, learned counsel, is present on behalf of the applicant. Mr. R. Borua, learned counsel, has appeared. APP, learned APP Assam, has appeared from the state. Full stop. By the applicant in this case was arrested in connection with Rota PS case number 59/2022, registered under section 341/354(b) of the IPC, read with section 8 of the POCSO code.
Time being letter item 51 and 52. Lordship had talked to Miss S.B. Bora. Lordship, on the first date only it was granted on the ground that your Lordship, he was a medical veterinary officer and bona fide belief he issued a certificate. Because Lordship, it's reflected in the second bail application
52.
at page 14, item number 52, page 14, name of that person, Upendranath Kolita. His name is there, your Lordship.
So they were arrested when? 30th of,
Lordship,
30th
one
of
was
November.
arrested on 30/11, item 51 and 52, 112. Lordship, Siri may be called for. They are specifically named in the FIR, my lord, these two persons.
the other applicant was.
Upendranath, yes,
Upendranath was not named.
Upendranath was not named. His name is there, your Lordship, in the forwarding at page 14 of the item number 52.
He's a veterinary doctor.
Yes, because this accused person has submitted some false certificate, and on bona fide belief he issued a certificate regarding health of the cattle's, my lord. On that ground only, this honorable court granted bail to them. mailed to him.
But how much time you need for the CD?
Lordship, it's from Chirang and before the vacation on
No,
21st,
Friday,
Friday.
Friday. We'll make it clear that if the CD is not available on the next day, the court will consider,
But these persons are specifically named.
that's all right, but you get time till Friday.
Yes.
These are not heinous offenses. So you wait till Friday.
Yes.
Heard Mr. A.M. Ahmed, Learned Counsel for the applicant. Also heard Ms. So-and-so Learned APP, Ms. B. Bhuya Learned Senior Counsel in APP Assam, assisted by Ms. M. Chakravarti, Learned Counsel appearing for the state, who prays for and is granted time till 16/12/2022 to produce the case diary. First of all, it is made clear that considering the nature of allegation made in the FIR and the fact that a co-accused has already been granted bail by order dated 9/12/2022, passed in bail application number 3397 of 2022. If the CD is not available on the next date fixed, the court will proceed on the basis of materials available on record and pass appropriate orders. In the next item, item 52, list along with item 51.
Obliged.
Item 21.
Hey, please, Lordship.
Lordship, the scan copy was called for Lordship and that has not been received, Lordship.
Peruse the scan copy, Lordship. The charge is yet to frame, Lordship. Okay.
This is not received, it has been received.
Lordship. But
Scan copy.
in the office note, Lordship, that I have seen, it is not received.
Charge is charge sheeted case.
Charge that case, Lordship. Charge is yet to frame, Lordship. It's an intermediate quantity, Lordship. 10.81 grams of heroin recovered, Lordship.
Then why don't you apply before the trial court?
Lordship.
Huh? You're Mr.
And Hock, Lordship.
Mr. N. Hock, Learned Counsel is present on behalf of the applicant. Mr. R. Borua, Learned APP Assam, appearing for the state, submits that since the charge sheet has already been submitted in this case and the charge is yet to be framed, the applicant be directed to seek regular bail before the learned trial court. Mr. Hock also agreed to the said recourse. Just in view of the above, this bail application stands closed by granting liberty to the applicant to approach the learned court below seeking regular bail.
Item 22.
Lordship, this 439 bail application. My lord, LCR was called for, it is charge sheeted case, my lord.
Why don't you approach the court?
Yes, I have approached by. Kindly see, my lord, page 27, annexure 7, my lord. Just rejected.
Actually, in the earlier matter, the trial court had not rejected the bail. The earlier one, N. Hock.
My lord, that order he has not enacted, Lordship.
All right.
But it is 50.78 gram heroin, my lord. It is not commercial quantities, below commercial quantity, but more than small quantity. My lord, I am behind about 207 days, considering length of detention, my lord. I may be allowed to go and bail. My lord, already few witnesses have been examined, my lord, in this case. This is 100,000 before your lordship.
Let us see. What is the quantity?
My lord,
What was the quantity?
15.78 gram. Commercial quantities, my lord, 250 grams.
Yes. 15.78 gram. Is it commercial quantity?
No.
It's a intermediate quantity.
And he's in jail 207 days.
Yes. My lord, I was arrested on 25/2022.
What do you say, Mr.?
My lord, there are, Lordship, 5 witnesses in the charge sheet, Lordship. So out of the 5 witnesses, 4 4 witnesses already been examined, Lordship. Last PW4 informant, he was examined on 23/11/2022. Now only the IO is left, Lordship. And evidence already come, Lordship, against him that it was found recovered from his house, Lordship. It was kept behind the refrigerator.
Yes, but the witnesses say it is 15.7 gram of drugs.
Yeah, that is
It was for his personal use. He was not a peddler.
That we cannot say, Lordship, because 15.78 Lordship is powder, Lordship. Powder is substance, Lordship.
We'll let him go on bail at this stage. If he's convicted, he faces the charge.
Only my objection may be recorded.
What is the punishment for this intermediate?
Yeah, up to 10 years.
My Lord, extended up to 10 years, Lordship.
Four witnesses have been examined.
4.
Yeah, Mr.
Bipul Buragoy. B. Buragoy.
Heard Mr. B. Buragoy, learned counsel appearing for the applicant. Also heard Mr. R. Burga, learned APP Assam appearing for the state. Full stop. The applicant in this case was arrested on 25/2022 in connection with
The word PS case number 12, 2022.
BU Board PS case number 12/2022 registered under section 21 bracket B, small b, bracket close of the NDPS Act 1985. Full stop. After submission of charge sheet by the police, the learned trial court had framed charge against the accused person under section 21 small b, bracket close of NDPS Act, and the trial has already commenced. Full stop. It appears from the LCR that out of the 5 witnesses named in the charge sheet, as many as 4 witnesses have already been examined, and only the statement of the IO remains to be recorded by the learned trial court. Full stop. Mr. Buragoy submits that the quantity is only 15.78 grams, which is an intermediate quantity.
My Lord.
And since there is no allegation of drug peddling against the applicant, and considering the fact that the maximum period of jail sentence in this case could be up to 10 years, the present is a fit case where the applicant should be allowed to go on bail during the pendency of the proceeding before the learned trial court. Full stop. Mr. R. Burwa, learned APP Assam, on the other hand, has objected the bail prayer by submitting that the recovery of 15.78 gram from the residence of the applicant not being in dispute, the present is not a fit case for releasing the applicant on bail, full stop. I have considered the submissions of learned counsel for both the sides and have perused the scanned copy of the LCR, full stop. It appears that 15.78 grams of heroin was recovered by the police from behind the fridge of the applicant in his residence, full stop. However, it is not the prosecution case that the applicant is a drug peddler, full stop. The quantity is also admittedly intermediate, within quotes, intermediate quantity, full stop. Considering the fact that 4 of the 5 witnesses have already been examined by the learned trial court and the grounds stated in the application, I am of the consider, as well as the fact that the applicant has spent more than 207 days in custody. I am of the opinion that the present is a fit case where he should be allowed to go on bail. Stop. Ordered accordingly, the applicant be released on bail on furnishing a bond of rupees 50,000 and 2 local sureties of like amount to the satisfaction of
Special Judge Shipsagar.
learned Special Judge Shipsagar, subject to the further condition that the applicant shall report before the learned Special Judge once every fortnight and shall not leave the jurisdiction of the learned trial court without prior written permission. Full stop. Failure to comply with the above condition may lead to cancellation of the bail. Full stop. His bail application stands dismissed.
Highly obliged.
EOP Act, my lord, to our information, charges submitted on my lord, 17/10/22. We have been informed by the pardon. So scan copy may be called for because that's my name. In fact, he's not named the FIR, he's not named my lord. Only his falsehood, my lord, that he has supplied, he has given one SIM card to him on good faith.
Charge sheet has been submitted.
Submitted on 17/10/22 as far information received by us.
And the trial court has rejected the bail.
Yes, that is. Page
Where is the order?
Page 21.
That is after submission of charge sheet.
No, prior to that. During the pendency, it was filed, madam. This case was filed on my lord prior to the first submission of the charge sheet.
Then why don't we ask him to approach the trial court seeking bail?
But he is already on custody, my lord. So if your worship may examine the scan copy, my lord, that again, my lord,
That will not do. That is not. But now the trial courts have been instructed to consider matters objectively.
that is up to your worship, my lord, but things will remain same, my lord. What I want to say, my lord.
That's what I was saying. It may not be the same.
But to my lord, I wish, my lord, this happens. My lord.
Let the also system recoup and we'll see what happens. Everything is before the trial court. We'll grant you liberty to come back again. Let us see what the trial courts are doing. How long this will continue? Trial courts,
But that, my lord,
forget the trial court, you do everything. That cannot go on.
no, it will continue, my lord. Normally, my lord,
Let us change it. Let's try and change it. If the trial court does not grant you bail, you come back, then we'll get a chance to also examine.
So liberty may be given.
Sorry?
With the liberty of your worship's liberty to.
Yes,
come
yes, yes. Mr. H.R. Chaudhary, Learned Senior Counsel, assisted by Mr.
IU Chaudhary, Lord.
A. Chaudhary, Learned Counsel for the applicant, submits that charge sheet has already been submitted in this case, and therefore the scanned copy of the LCR be called for. First of Mr. R. Burwa, Learned APP Assam, on the other hand, submits that the applicant should be directed to approach the learned trial court before before praying for bail from this court. After taking note of submission of learned counsel for both sides, This bail application is hereby closed by granting leave to the applicant to approach the learned trial court seeking bail. Full stop. The applicant would be at liberty to approach this court thereafter if he continues to be aggrieved in the matter.
May please, your lordship. My lord, this petitioner was arrested on, my lord, 25/10/22, my lord. Now, the FIR, of course, my lord, raises a very substantial issue, my lord. But so far as the present petitioner is concerned, perhaps he is not associated with all these activities. The original FIR is at page 28, my lord. And in the original affair, petitioner is not named either. Now, my lord, this FIR name accused Habel Ali. He possibly, my lord, made a statement based on which, my lord, I was taken into custody. Now, if your lordship would kindly come to page 33, my lord, the statement of Habel Ali, which was the premise for arresting the petitioner. Page 33 on top. As per the statement of already arrested accused person, Habel Ali and so, the organizer of Mia Museum received inspiration and financial assistance from the organization of so. My lord, I am not the organizer of this Mia Museum. I was in fact invited to, my lord, sort of open the thing, my lord. I'm not a part of that organization. And other than the statement of that co-accused, my lord, there is nothing is there. And I'm already in custody from 25/10/22, my lord. And I'm a retired lecturer of a college. In fact, my lord, I'm doing a lot of social work. It has been acclaimed also. So that
Where is the FIR, Mr. Chaudhary?
Yes. Original FIR is at page 28. On 15/10/20, credible secret source input backed by technical intelligence was received that some activities of a global terror outfit banned by Government of India are going on under the jurisdiction of Ghagrapar PS. On preliminary inquiry by Ghagrapar PS GD number so it was found that a module of Al Qaeda in the Indian subcontinent is active in so with linkage to other districts of Assam as well. It was revealed that the identified module also has an affiliation with the Bangladesh-based religious fundamentalist and a possible linkage to the Bangladesh-based terror outfit, namely ABT, which has ties with AQIS. It is learned that Sadek Ali, Habel Ali, Zakibul Ali, Abu Raihan, and Zubair Hussain have been involved in banned activities of waging war against the Union of India by indoctrinating minds of various people. On sustained questioning of Habel Ali, who was apprehended on 16/10/22, he stated that object of their organization is to propagate terror in Indian territory, radicalize like-minded youth and carry out regular recruitment and training process to wage war against the state of Indian Union with a view to overthrow the democratically elected government and to carry out jihad, terror activities and to kill kafir persons of other religion and to establish the Islamic State in India. During the course of the preliminary interrogation and charge and seizure at the residence of Habel Ali, mobile handsets were seized. Seizure list prepared. Technical analysis of the mobile phone reveals accused Habel Ali has consumed and propagated the idea of jihad.
So you say that the applicant has been arrested only because he went to inaugurate a Mia Museum.
Yes, that is the case.
He opened, according to his statement, he says that he inaugurated a Mia Museum at Gwalpara, and that is where that is his activity. He denies the allegation of this jihad or etc. Al Qaeda. But other accused who was arrested, he says they say, and the Mohar Ali and this petitioner, Are the person Maharali is a subject teacher of a high secondary school, and he is lecturer of a college. They are alluring youths to join jihad and Al Qaeda.
No, no, what is about this applicant? Show us that.
Yes, 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 I'm saying. There are many persons, my lord.
No, no, we are,
Was-
Mr. Das, we are only concerned about the
Yes, his name is,
applicant here.
I'm saying, from the statement. of-
Inaugurating a museum cannot be
That
termed
is
as a.
different thing, my lord. I am not on that, my lord. বহুত মানুহৰ নাম কৈছে যে he was not asked to Zubair Hussain. He was asked to join this jihadi group. বহুত মানুহৰ নাম কৈছে যে তাৰ ভিতৰত আব্দুল বাটাৰৰ নাম মোৰ মনত আছে মানে they are saying these people who are alluring the youths to join jihad or Al Qaeda. There are so many persons. About those persons, this accused person was told their name. And among them, বহুত মানুহৰ নাম কৈছে যে তাৰ ভিতৰত আব্দুল বাটাৰৰ নাম মোৰ মনত আছে।
কি context?
No, what is the
Regarding
context?
What is the context?
That is the questioning. Who allured them to join this jihad?
No, no, this sentence must have some prelude, some.
Yes, yes.
What is that?
I cannot read out.
All right, you can-
entire
Read it on the report.
You
Because
just
in open court.
flag mark.
Yes, I have.
All right.
I don't like that. It's only for lordship's eyes. Yes, we don't want to.
That is why I did not like to read out an entire. This is not Habil Ali, my lord, as has been referred to my learned friend.
No, no, I'm reading from the
No, I
forwarding
understand, I
statement.
understand.
In the forwarding
No,
statement, it
Habil
was.
Ali Muhammad.
It's just one statement which is capable of dual interpretation. Which can
Now,
be interpreted
this
either ways.
one thing, my lord. Your lordship may kindly peruse his statements also. His statement, I have flag mark, my lord.
Hmm.
Ab-
Applicant,
Batil.
applicant.
Applicant, my lord.
Hmm.
Abdul Batil. Now they are planning to, my lord, open, I'm telling the gist, my lord, to save your lordship's time. My lord, he says, my lord, they have constituted an organization to, my lord, open up Mia Museum in every district. And that funding is made by this one. Only he is subject teacher, my lord, Sonali or something like that, my lord. And where from money has come, my lord, he doesn't know. And being a subject teacher, he is subject teacher, but he has, my lord, secured one PMAY, my lord, house, Prime Minister Awas Yojana
No,
house.
these are different things.
My credibility of my lord person, you will also will kindly look into.
As in, good mobile.
Prime Minister, he ঘৰলৈ বহি আছে আৰামত আৰু টিউচন বিলাক
Science subject did you have?
Prime Minister ঘৰ লাগে তাত। His mobile has been seized.
Hmm.
That is being examined by the.
All right, so he's been in custody for close to 2 months.
More than 2 months, madam. 25, Aji Kiman Tariq?
Arrested on
25/10. More than 50 days.
Offense under UAPA is not life. 90 days offense. I leave it also. Well, my objection will be recorded.
heard Mr. K. Chaudhary, I'm senior counsel assisted by who's? Mr.
A. Paramanik.
Paramanik, learned counsel for the applicant. Also heard Mr. D. Das, learned APP Assam, appearing for the state. First up, the applicant herein was arrested on 25/10/2022 in connection with 26/10/2022 in connection with Ghagra Par PS case number 163/2022, registered under section 120 bracket B bracket close /121/121 bracket A bracket close /122 of IPC, read with section 10/13 of the UAPA Act, 1967, and since then he is in custody. By filing this present application, the applicant is seeking his release on bail. Full stop. Mr. Chaudhary, learned senior counsel for the applicant, submits that his client has been in custody for more than 50 days, and there is nothing incriminating available against his client. Full stop. According to Mr. Chaudhary, the applicant is working as a lecturer.
No, he is retired, my lord.
He's retired.
In 2021.
He's retired as a lecturer from a government college
Yes.
and is involved only in social activities. Full stop. Merely because the applicant has taken part in inauguration of a within course Mia Museum, that cannot be a ground to prosecute him under the provisions of UAPA Act, 1967. Full stop. While raising strong objection against the prayer made in this application. Mr. D. Das, learned APP Assam, has produced the case diary. First up, I have perused the same. First up, according to the learned APP, the applicant, there are preliminary leads to indicate links of the applicant with jihadi forces as well as funds flowing from the Al-Qaeda. Full stop. Full stop. After perusal of the case diary, and after hearing the submission of learned counsel for both the sides, I do not find any justifiable ground to permit further custodial interrogation of the applicant, more so since his statement has already been recorded and the mobile phone, etc., held by the applicant has also been seized by the police. Full stop. Moreover, the funding from any terrorist organization, if any, is a matter which can be traced by the investigating agency by adopting various means which are available in public domain today. First up, in view of the observations made above, the applicant is hereby directed to be released on bail on furnishing a bond of ₹50,000 and 2 local sureties of like amount, subject to the further condition that he shall not leave the jurisdiction of the IO without written permission, and shall render full cooperation in the investigation in connection with the aforesaid police case. Full stop. It is made clear that violation of the above conditions may lead to cancellation of the bail. Bail application.
Item 25.
My lord, 31 kg ganja, my lord. He is a driver of a magic. Actually, that belongs to his brother. And he was driving and the passengers were there, and his case is that some of the passengers left it in the car. It will recover from his vehicle. Today is already 293 days. And scan copy was called for, my lord.
NDPS matters, normally this is the explanation.
That's,
I don't know. Somebody has put it in my bag,
that's my, but,
somebody else's car. Beyond that, what else can be said? Recovery is made, contraband proved. What else? We understand your predicament also.
that is there, madam, from the vehicle.
What else can be argued in the bail?
No, my only question, madam, this stage, ultimately, madam, that scan copy of lordship, I do not know what actually, madam, witnesses are stated by the.
Have you examined this?
Yes, Lordship. My lord, has already framed, Lordship, and there are six witnesses in the search sheet. And out of 6 witnesses, 3 have already been examined, Lordship. They are police personnel, Lordship. They are just seizure witness, Lordship. They said that it is contraband recovered from his position.
Commercial quantity.
Commercial 31 kg, 20 kg is the commercial one, 31 kg. That is their madam, commercial quantity. Only madam, 3 already examined. And 3 remains, total out of 6 madam.
When is the next date fixed? Any idea?
My lord,
19 madam, he said. 19 to.
let it be in the month of January, Lordship. Subject to my lord.
3rd January?
21. On the 19, it is fixed for next year. On 19, it is fixed.
So when 21st?
The scan copy has to be called for. Scan copy, Lordship, is somebody.
They will produce certified copies.
My lord.
21, I will not be there. 20, it is possible or not, I do not know. 20, if possible. Sir.
20.
We'll try, madam. We'll try to get a certificate.
Mr. H.R. Chaudhary and Senior Counsel assisted by Mr. M.R. Kharnakar submits that as many as 3 witnesses have already been examined, and the next date for examining other witnesses is fixed on 19/12/2022 before the learned trial court. Post up. Mr. R. Borua, learned APP Assam, submits that let this application be considered after the evidence of the witnesses are recorded by the learned trial court. In view of the urgency expressed by Mr. Chaudhary, and on his request, this IA is directed to be posted again on 20,
20.
2022 as a fixed date.
Much of them.
Item 26.
My pleasure, Lordship. On the last date that CD was called for, my lord.
My lord, we have not received the case.
My lord, my only prayer is that I would like to pray for a date before our vacation, my lord. Okay, the petitioner is behind bar for 112 days and the seized quantity is, my lord, 1.04 kg, my lord. And the stated period is 60 days.
21st December.
My lord.
Heard Mr.
1.04.
R.B. Gohain, learned counsel for the applicant, Mr. R. Bora. Learned application appearing for the state submit that the case diary as called for has not yet been received. On the request of learned counsel for the parties, this matter is therefore, directed to be posted again on
2012.
2022 as a fixed item.
Hello, Lordship.
Item 27.
Yeah, your lordship. Lordship, the petitioner was arrested on 6/6/2022 under section 21B of NDPS Act. And today it's 190 days behind the bars, lordship. Lordship, may kindly peruse page 19.
21B,
Yes.
Intermediate quantities.
what is the contraband?
Heroin also.
How much?
25.8 grams. Lordship.
It's behind the bars for last 189 days, lordship. And page 19 is the last reject order,
Page 19
lordship.
is the last.
Reject bail, reject order from the court. Lordship. Already proceedings started, one witness already examined, lordship.
How many witnesses have been examined?
My lord, there are 6 witnesses in the search sheet, lordship. Out of 6 witnesses, only one examined, lordship.
Lordship, on
And I
last
have
occasion,
trademark date, lordship, evidence of PW1.
last date was fixed on 8/12, lordship, no one appeared on that day. Moreover, lordship, the petitioner is the only bread earning member of the family. And he got minor child and old aging parent, lordship. Lordship, may kindly consider the length of detention.
When is the next date fixed?
I'm not aware, lordship.
My lord, 8/12, lordship.
8/12 already
8/12
on
is
last.
gone. There are
Gone, lordship, and no one.
Status report is up to, lordship, before 8/12, lordship. That is why it is mentioned as 8/12 for further evidence.
Lordship may impose any condition, lordship, and allow the petitioner to go on bail. He's ready to face the trial, lordship. He's a driver by profession.
So what do you have to say on the charge, on the allegation?
Lordship, is pleaded not guilty, Lordship.
My lord, charge of already framed lordship and prosecutor witnesses examined lordship. Now PW1 is the truck driver lordship in whose vehicle the accused person he boarded lordship. Accordingly, during the police check lordship, this contraband was found from his bag lordship. So there are already evidence against him lordship.
That is intermediate quantity.
Intermediate quantity.
Lordship.
So he's been in custody for how many days now? 190 days.
190 days.
89.
What do you say on our prayer to release him on bail? He'll face trial.
My lord, considering the lordship severity of the offence lordship, this is all lordship NDPS Act or Special Act lordship.
But how many will you put in the jail? The jails are overflowing.
That is true.
Lordship,
lordship,
Propose any ground.
but in case of 37 also no not come records of 37 lordship, because it's a intermediate quantity lordship.
37.
37 will not come lordship because it's an intermediate quantity lordship.
What does 37 say?
37 lordship, in case of commercial quantity lordship, the satisfaction has to be drawn lordship before granting bail lordship. That he is not guilty of the offence lordship, and in the event of releasing him on bail lordship, he will not commit the same offence again lordship. That is the two conditions that has to be fulfilled lordship. But in this case, the 37 will not come lordship. Only consideration is that lordship, this is NDPS Act or Special Act lordship.
That's all right, but law will take its course. We are not on that.
And the second aspect is that
Is
lordship,
there any
only-
law that NDPS no bail should be granted?
No, it is not that lordship, but since it's a charge-sheeted case lordship, and only one PW prosecutor witness has been examined lordship. There are 5 others.
Oh, can there be a bail application in a case where final report is submitted? Yeah. Yes, these are all charge-sheeted cases.
My lord,
190 days means more than what, 6 months?
my lord.
Hmm? Let him go on bail. We'll see. Heard Miss KK, your KK Chaudhary,
Lordship.
counsel appearing for the applicant. Also heard Mr. R. Borua learned APP Assam appearing for this state. First up, the applicant herein was arrested on 6/6/2022. In connection with Basista PS case number 584/2022, registered under section 21 bracket B, small b, bracket close of the NDPS Act 1985, and since then he is in custody. Full stop. The prosecution case is that contraband item, bracket heroin, bracket close, weighing 25 grams was recovered from the possession of the applicant while he was traveling in a truck. Full stop. The case has been charge sheeted and the accused is facing trial. Full stop. The LCR scan copy of the LCR called for by this court goes to show that only one witness has been examined so far. And on the last date, the witnesses of the prosecution side did not appear. Full stop. Contending that the applicant as a minor child, applicant who is the sole breadwinner of the family, there's a minor child to look after. And that Mrs. Chaudhary submits that the accused will face trial if granted bail by this court. Mr. Borua, learned APP Assam, on the other hand, submits that although this is a case of intermediate, within court's intermediate quantity, yet considering the gravity of the offense, the prayer for bail be rejected. After perusal of the record, I find that the accused has been in custody for nearly 190 days. And the conclusion of the trial by recording the evidence of all the 6 witnesses, is it? All the 6 witnesses may take some time. As such, after taking note of the facts and circumstances of the case, this court is of the opinion that the applicant has made out prima facie case so as to release him on bail. It is accordingly ordered that the accused, namely so-and-so, Surab Ali, be released on bail on furnishing a bond of ₹30,000 and 2 local sureties of like amount to the satisfaction of the learned. This is what special judge?
This is Special Judge Kamrup Metro.
Kamrup Metro, subject to further condition that he would record his attendance before the learned trial court once every fortnightly and remain present on each date of trial. Full stop. The applicant shall also not leave the jurisdiction of the learned trial court without prior permission. Full stop. A violation of any of the above conditions may lead to cancellation of the bail. Bail application stands disposed of.
Highly obliged.
Item 28.
May I please, Your Lordship. Proceeded case, Your Lordship, on earlier occasion, scan copy was called for, but he had not received, Your Lordship.
My lord, not been able to go to the scan copy also.
Not received it.
Not received.
It's been received.
Received.
Both of you examine it.
Day after tomorrow.
On the request of learned counsel for both the sides, this matter be listed again day after tomorrow so as to enable the learned APP to examine the scanned copy of the LCR.
Item 29.
Again, so have a latest.
Lordship 439, both husband and wife before this lordship, Your Lordship. Now 35 days till today behind the private lordship. So for the allegation in this FIR concern,
POCSO.
POSCO, but so for POSCO section is concerned, this is not retracted in respect of the present petitioner before Your Lordship.
Please, Your Lordship. The 439 application, Lordship. The FIR is a page 13, Lordship. May I read the FIR, Lordship? Page 13, Lordship.
Case diary?
Yes, they received also.
Page 13, the vernacular FIR, Lordship.
Page 13.
13, Lordship.
13.
13, Lordship.
Yes.
May I read the FIR, Lordship?
Yes.
সন্মানপূৰ্বক বিনীত নিবেদন এই যে মোৰ ফুলখালী মেহবেজ বেগম বয়স 18 বছৰ এজন ল'ৰা চফা চাঞ্চৰীৰ সৈতে যোৱা প্ৰায় 1 বছৰৰ পৰা প্ৰেমৰ সম্পৰ্ক আছিল যোৱা প্ৰায় 1 বছৰ আগৰ পৰা দুয়োগৰাকীৰ মাজত শাৰীৰিক সম্পৰ্ক আছিল বুলি মোক ফুলখালীয়ে জনায় যোৱা 2021 নৱেম্বৰ 5 তাৰিখে নগাঁও ষ্টেডিয়াম
430 rebellion, my lord. FIR case 10, my lord. Petitioner is an interim, my lord.
My lord, we have received the case diary, Lordship. There is a IOS note in the case diary. My lord, IOS said that he has cooperated with the investigation. He has cooperated with the investigation, Lordship. So his custody interrogation may not be required.
He is already on interim bail.
My lord. Yes.
Heard Mr.
S. Rahman.
S.
Rahman.
Roman learned counsel for the applicant. Also heard Mr. R. Borua, learned APP Assam appearing for the state, who has produced the case diary. A perusal of the case diary goes to show that the applicant has cooperated with the investigation and his statement has also been recorded. First up, after going through materials placed before this court, I am of the opinion that custodial interrogation of the applicant would not be called for in this case. As such, the interim order dated 5/8/2022 passed in this case is hereby made absolute. Bail AB application stands disposed of.
Right.
Item 34.
My lord, 34, we have not received the case diary.
All right. Heard Mr. H. Ali, you are Mr.
Yeah.
Ali, learned
He is on interim, Lordship.
Yes. Mr. R. Borua, learned APP submits that case that he has called for has not yet been received. In view of the above, after vacation.
After the 10-1.
Let this matter be listed again on 10/1/2023. Interim order passed earlier.
Item 35.
Yeah, I see.
Mr. N. Sheikh and Mr. R. Borua, same order, 10/1. Case diary not received.
My lord, case diary not received.
Yes.
Interim order. My lord,
My lord, for 30 application in connection with my lord, Dasivara PS case number 210.
36 city received?
Yes, my lord, 33, we have received the case diary.
My lord, do you find the my lord FIR Varnagula portion, my lord, page 12, my lord. Question may kindly turn to page 12, my lord. The allegation part, my lord. My lord, relevant portion, my lord. সম্মান को বিনীত নিবেদন এই যে মোর নাবালিকা সোয়ালি জেসমিনা বেগম 14 বছর সময় 11 দিন 11 দিনের জুয়া 10/7/2022 ইংরেজি তারিখে দিনের অনুমান 11:30 মান বজাত
His client has in the meantime being arrested and therefore the application has become infructuous. Mr. R. Burwal, learned AP Assam is present on behalf of the state. Taking note of this application, this submission of Mr. Chutia, this AB application stands disposed of as infraction.
Item 39.
Is there is received? Please read your lordship. The 438 application, because there is no interim, my lord. Your lordship kindly see the annexure 1 page 10, my lord.
Annexure 1,
Page 10. Very small assignment.
yes.
With due respect, I want to inform you that my elder daughter got married to Injamul Haq on 10/12/2021. After marriage of my elder daughter, my younger daughter, namely Ina Hussain, sometime visited the house of Abdul Ali, who is the relative of the son-in-law, who is situated in Mirza, Galip Pat, Hatigaon. On January 2021, one day, she visited the above named Abdul Ali's rented house and suddenly. Prior to these incidents, your lordship, on my lord, I have on 4/7/2022, my lord, I have given the vehicle to the driver for loading the truck on one trip of Lokhara, my lord. Thereafter, when about 4 or 5 days when he did not return, my lord, I have a lodged one complaint before the Kamalpur PS, my lord. Kotasil Ambari, my lord.
When did you lodge the complaint?
My lord, that complaint was not registered, my lord. But I have cooperated to the investigation, and I have mentioned in my
So
paragraph.
any proof, can you show any proof that you means the applicant had
My-
lodged any complaint or HR with the police station?
No, my lord, no document is there, my lord, but I have mentioned in paragraph 5, my lord, on fourth, my lord. That after 4 or 5 days, my lord, I inquired about my vehicle, my lord.
Hmm.
Therefore, on 9th, my lord, the vehicle was found in the abandoned condition in the Kamalpur PS, my lord. And I am the registered owner, my lord, and I have stated in my petition regarding the driver of the vehicle, my lord. I have also annexed the copy of his driving license, my lord. And prior,
The driver has been arrested.
driver is not arrested, no? No, not arrested, my lord.
The vehicle was found abandoned condition on the street.
Hmm. And they are absconding, the driver and the handyman.
Yes, my lord.
With all respect, I said, the heroin, tramadol, morphine, opium, morphine, use quantity. This is not a fit case for anticipating.
My lord, in my life, my lord, I have not done any criminal background, my lord. And so far, page 13, my lord, forwarding report.
Can you produce anything to show that the owner had lodged a complaint? Anything, any material? That is your only chance.
My lord, I understand, my lord. My lord, for that we can try at Fortasil PS, my lord, because there must be some GD entry, because we have cooperated with the investigation at Fortasil Ambari prior to the lodging of Kamalpur PS, my lord, in order to search my vehicle.
Can you find out if they will postpone it? If there's
Maybe
any-
given an opportunity, I have no objection to that, but
How much time you want for that? 1 week,
10 days, my lord.
10 days?
10 days, my lord.
On the request of Mr. S.K. Jain, learned counsel for the applicant, let this matter be listed again on 21/12/2022, so as to enable him to obtain instruction and appraise this court as to whether there is any GD entry made in the Potasil
Potasil,
PS police station on the alleged complaint made by the applicant that his vehicle had gone missing while in custody of the driver. Full stop. Mr. D. Das, learned APP Assam is present on behalf of the state.
One thing, Lordship, can I pay, my lord? Can I give one interim protection, my lord? Because I have to go there to find out the GD.
Find somebody else to do it.
After receiving case there, if Lordship find any material, then
Not now. You show something because we are taking a strict view in NDPS matters.
my lord, agree, my lord.
Because you can't help it. Some cases there could be some scope, but then let the message go that NDPS, you will be in trouble.
My lord. What's it?
Yes, 21st.
Obliged.
41.
Particularly commercial quantity.
Maybe your lordship.
Hmm.
Lordship 431, 438 application,
Hmm.
and FIR is at page 11. The type copy is at page 11, annexure 1, and vernacular is at page 12.
They are on interim bail.
Yes, lordship. We have appeared before the IO,
Hmm.
and some cows were seized, and we were the owners of those cows.
Yes, Mr. Das, what is that? Their statements have been recorded. Yes, heard Mr. S.N. Tamili, learned counsel for the appeal. Also heard Mr. D. Das, learned APP Assam appearing for the state. Who has produced the case diary? I perused the same. After perusal of the materials placed before this court, I am of the opinion that the interim order dated 25/11/2022 is liable to be made absolute in this case, ordered accordingly. This AB application stands disposed of.
Much.
Item 42.
May I please, your lordship, the 438 application, lordship, the allegation is under section 13 Assam Cattle Preservation Act, lordship.
Is there received?
Is the receipt? The petitioner number 1 is the owner of the vehicle, I think, and petitioner number 2 is the purchaser of the cattle. Or he has submitted certain documents regarding purchase of his cattle. My lord.
Heard Mr. Chutia, learned counsel for the applicant. Applicant also heard Mr. D. Das, learned APP Assam appearing for this state.
Their statements are recorded.
Applicant has approached this court by filing this application. And the applicants, two applicants.
Two applications, lordship.
Actually, applicants, the applicants have approached this court by filing this application under section 438 CRPC, seeking pre-arrest bail, apprehending arrest in connection with Barbarua PS case number 115/2022 under section 11 bracket numerical 1 bracket close bracket small a bracket close bracket small b bracket close of the Prevention of Cruelty to Animals Act 1960, read with section 13 of the Assam Cattle Preservation Act, 2021. First up, the learned APP has produced the case diary. I have gone through the same. The statement of the applicants have already been recorded by the IO. Full stop. After going to the case diary, I do not find any justifiable ground to deny the privilege of pre-arrest bail to the applicants. Stop. As such, it is hereby provided that in the event of arrest of the applicants, namely so-and-so and so-and-so, in connection with so-and-so case, they shall be released on bail on furnishing a bond of rupees 30,000 each and one local surety of like amount to the satisfaction of the arresting authority. Stop. The AB application stands disposed of.
Obliged, lordship.
Item 43.
43, I'm sorry, there is not received. We sent the requisition on 6/12, but it is not arrived.
There is interim bail.
No, your lordship.
6/12, then you will need time 2012.
Madam.
From which PS?
This is
Sonapur, Sonapur PS. your lordship.
Sonapur.
Sonapur.
2012 you get it, huh? You waited.
Hi, lord.
Your name?
Nabanita Chakrabarti. Nabanita Chakrabarti.
Miss Navanita Chakraborty has appeared for the applicant. Mr. D. Das, learned APP Assam submits that case diary as called for has not yet been received. As such, on the request of the learned APP Assam, this matter is directed to be listed again on 20/12/2022, so as to enable him to produce the case diary.
Highly obliged.
For orders, item 44 and 45.
May it pleases your lordship. This is that 454, 468 matter of the Companies Act. Here I have been informed by the official liquidator, my lord, that he has finally prepared the dissolution report, my lord, the final report of dissolution of the company. As the directors and creditors, there is no one, my lord, and nothing could have been done. And he has submitted the same before the joint registrar on 8th of December in the main company petition, which is company petition number 10 of 2011. So I may pray, my lord, your lordship may adjourn these matters and fix it along with the main company petition.
Mr. K. Goswami, Lion Senior Counsel, assisted by Mr. B. Chandelier, submits that as per instructions received by his junior, the official liquidator, bracket OL, has already prepared the final dissolution report pertaining to the company and placed the same on record on the file of company petition, company application.
Company petition
Company
number
petition number 10/2011, which is pending disposal before this court. Therefore, this matter be taken up after the winter vacation along with company petition 10 of 2011. These matters, prayer allow registry to list these cases. This is 44 and 45.
my lord, and maybe one more sentence, my lord, that the letter dated 8/12/22 addressed to the joint registrar judicial may be also brought on record, right? This is by which the report was submitted, my lord.
List this matter again on, we'll have it after
Anytime, my lord.
on 18th of January 2022, along with so-and-so, as well as the letter dated 8/12/2022 issued by the OL to the joint
Registrar judicial.
judicial. Yes.
Deeply obliged.
Item 46.
Yes, who is appearing? Name not shown. None appears for the applicant petitioner when the matter is called up. As such, this IS stands adjourned for 2 weeks. Yes.
Item 47.
Lord, there are two IAs, one filed by the other side. There, of course, the company petition and we are for the other side. And Lord, we are saying that this petition, company petition itself is not maintained. And they would like to say, in view of coming into force of the IBC court, therefore the matter has to go before the NCM. That is what they have urged in their IA.
We have filed the IA 2575 requesting for transferring the whole petition to the NCLT so that the NCLT is the ultimate authority jurisdiction to dispose the case, whatever merit of the case.
No, my lord. It's not that simple. And the question of transfer will come only when, my lord, they fulfill the prescribed conditions laid down in the act. It's not automatic.
It is our request only to transfer the case to the petition.
No, there is nothing like request in a code of law.
This is as per the amended.
All right, now this will have to be heard.
This has to be heard.
How much time will it take?
I'll take about half an hour, my lord.
The court is rising at what time? Today, court is rising at 3. Will you be
In
able
that
to
case,
finish it?
also will fix a date after the vacation.
Can we fix a date? Convenient date? After the vacation, I think.
Mr. D. Sahu, Learned Counsel, as well as Mr. K. N. Chaudhary, Learned Senior Counsel, appearing for the other side, have jointly submitted that since both the interlocutory applications are contested matters, some time will be taken by both of them to argue the cases. On such ground, a prayer has been made by Learned Counsel for both the sides to list these cases anytime after the ensuing BU Bihu holidays, full stop. Taking note of such submission, registry is directed to list these matters again on 19.
Let it be on, let it be on 19 already, a few matters are fixed, my lord. 24th. Yes, okay.
24th.
Is a Tuesday, my lord.
24th of January 2023.
Yes.
As fixed items. Acha. Miss M. Rahman is present on as well. Who else? Miss M. Rahman, counsel for the private respondent is also present. Yes. Yes, please.
Okay.
How many more there? Yes. Mm.
For hearing item 49.
Mm. What can be done in this case?
My lords, insofar as the liability is concerned, my lords, if a lordship goes to see who is negligent, the negligence of the PHE is on record, my lord, because the electrical inspector's report as well as the affidavit file would clearly disclose that they were negligent. They had demolished the earlier.
So you want only money?
Not only money, but my lord, so far as the judgments are concerned, my lord. In fact, the oleum gas case, my lord, which the compilation I provided, my lord, there the liability, my lord, the concept of liability has been somewhat diluted. Now, the Honorable Supreme Court holds, my lord, a industry or a business which carries on a hazardous business, the liability would be strict and absolute. Now, APDCL in that way.
That's all right. Ms. Chaudhary. You see,
Asalsa is concerned, Your Lordship, there's not much scope.
No, you
within the
forget
frame of the ambit of
Asalsa or
the
anything else.
Lordships.
Can you address the court on what would be a human approach to this whole issue?
Lordships would perhaps take the view of a constitutional tort having been committed. It is ultimately Article 21, the right to life of a child has been affected by way of the injury which has been caused. So perhaps that is the, and I'm sure my learned friend has placed the relevant judgments before your lordships, where the court has taken a broad view. And if Article 21 has been infringed upon, then thereafter the court has granted adequate compensation. There are several cases, your lordship.
That's what I'm asking, whether
Yes.
he wants compensation. He says no. Because some amount has already been paid.
4 lakhs has been paid, lordship, but
That's
that if
a
you lordship would
interim.
see the child has lost both hands. Now, a rehabilitation program and 4 lakhs is not going to be sufficient for a 12. How old is the child?
Now, he's my lord, 16 years, 2 months.
So appropriate compensation needs to be granted, your lordship. There are several cases of the
See, Ms.
apex court,
Chaudhary,
lordship,
whatever be the judgment,
lordships.
I will not devote more than one paragraph on the law. There is nothing more to write on the law.
Lordships.
Correct. The question is, what is the effective order that can be passed,
Lordship.
which is going to be of some use to the applicant? Merely by passing an order is not enough. It should be something which really helps. And perhaps the state will also not have a very adversarial stand in this matter. So, constitutional tort, you're right, right to life, Article 21, these are all established.
Lordship.
There's no need to write 30-page judgments on this. We have enough.
Yes, sir.
Correct. It's a clear case of negligence, and therefore the state has its liability. It's a case of strict liability. Only 2 paragraphs is enough.
Lordship.
And
If
we
your
can give
lordship-
reference to all judgments,
Lordship.
whoever wants to read.
If your lordships have already made up your lordship's mind about the fact that yes, there is a liability, then the compensation is entirely under 226 as to lordship's powers. The
What-
quantum of compensation would have to be perhaps used, normally, your lordships, what happens is that the multiplier effect, which was there as per the Motor Vehicles Act schedule, that is what is relied upon by the courts to assess as to what is
No, that's
and-
fine. Perhaps you were not there at that stage when the order was passed. And they were also
observed that regarding the legal.
correct. The reason why legal service was roped in, that message has not gone.
No, that must, I do not, I'm not aware of.
the idea is not to decide whether he should be compensated and how much money should be. This is not the idea.
Lordships.
Idea is how to make him live a life which is as close to what will he do with the money if he doesn't have his limbs?
Lordships. Lordships,
So the idea was first to see whether the limbs can be fitted.
that would fall under the jurisdiction of the social welfare department, because the social welfare department has access to all these schemes and also has access. I'm privy to this because of the fact that your lordships are aware. We do a lot of cases for social therapy for persons
So
with
that's why,
disabilities. So the social welfare department.
why don't you
would
be the amicus here and give us the way forward?
Lordships, the social welfare department has its own councils. They would perhaps be more aware of what all the schemes are. I have no difficulty in being the amicus and addressing your lordships on that. But the fact is that there are several schemes available, and there are also schemes available for providing artificial limbs to persons with disabilities.
That is
So
exactly why
his
the-
rights would now fall under the ambit of that particular act, the rights of that child. And there are several provisions in that act as well.
What happens is,
Lordships.
these are the reasons why Asalsa has been brought in.
Lordships,
Asalsa has been brought in to explore
unfortunately-
whether he can be sent to some place like Jaipur Foot and all where
Lordships, Asalsa
That was already
jurisdiction
done,
is
my
not,
It was already done, but it did not work because the length at which the arms have been amputed, the
It's not
Jaipur
going to work.
facility is not equipped with those kind of prosthetics. my lord.
oh,
And
that's-
in fact, if your
that's-
lordship, there's some doubt regarding what can be done with regard to the compensation. There's a case, my lord, I have produced in the compilation, my lord. It's Raman versus State of Uttar Pradesh,
So
2014.
we'll hear the matter at 2. How much time will you take?
PEC council and all these things, I have also wrote to the council earlier as by your lordship regarding his appointment.
Hmm.
I have already consulted with the council authority, whether he can be accommodated in the disabilities quotas or not. My lord, they can favorably consider, my lord, when he attains the age of majority, my lord.
Hmm.
And that is our role, my lord. We have taken a positive view like that, whether he can be.
Okay, the idea was to give him a job, to make himself.
And, social welfare department scheme is there, my lord. At this moment, my lord, lordships, whether he can be accommodated, amputated, hand can be, my lord, rehabilitated like that way. That can be at this moment it is the priority, my lord. So how it can be done like that way? Regarding the future, my lord, that after attaining the age of 18 years, my lord, I have already consulted, my lord.
That's correct. Ms.
lordship,
Chaudhary, the idea was to
Social
look
welfare
at it
department council also,
innovatively.
my lord, PSC
Rest
council
of the
and
things are already known.
APDCL also
Here
are
and
there.
pass judgment. That can be done in next
Yeah,
half an hour.
All the judgments are there, my lord.
But what will he do with the judgments?
Lordship,
Maybe, my lord, some psychology, because I have researched, my lord, people, victims such as the petitioner, my lord, they suffer from depression, which leads to morbidity, my lord, because some
That is the reason.
psychological.
The court wanted to know about a comprehensive plan
Lordship,
to rehabilitate this person suitably.
Lordship.
Just paying some money is the easiest thing, but what will you do with the money? Where will the money be kept? So give him some psychological, some physical support, something which can help him live his life independently.
Exactly.
These are the ideas. That is why this matter has been kept pending. Otherwise, if it was
In
simple.
fact, lordships, in one of the matters which I was doing, the social welfare department had produced 1 or 2 schemes whereby their physiotherapy sessions and other counseling sessions are also provided to the persons with disabilities at PHEs, at public health centers, PHCs, which are there in each of the district centers. So that those schemes are there and it's provided free of cost. So perhaps that might also, the social welfare department would be a very essential department, lordships. They have to come in because they are the ones who have all access to all these schemes, and the funds are also naturally, lordship, with them because of the fact that the central government provides them with funds for this particular schemes.
These are the things.
And there are,
The court wanted to know what is there, what scheme is there, what fund is there.
lordships, at 2, I'll apply to lordships. I did have a few, but I wasn't, I have no difficulty.
Consider APDCL, my lord, the public health engineering department council also here.
Actually, what about the other matter? Which is the other case?
50, madam.
Ready?
50, yes, ma'am.
But today the court is rising at 3. So,
I'll briefly narrate the facts, my lord. My lord, the petitioner before your lordship is 16 years, 2 months, my lord. His date of birth is 15/06/2006.
16 years.
16 years and my lord, this will be 4 months now, my lord. He was born on 15/06/2006.
Yes. What is the date of birth, please, once again?
15/06/2006.
Yes.
The father of the petitioner is a junior assistant, my lord, and they have a quarter situated in the campus of the office of the additional chief engineer, PHE, my lord, in Karbi Anglong. My lord, the office of the additional chief engineer, Karbi Anglong, was an Assam type house, my lord, which was demolished, and without taking permission from the APDCL authorities, a building, a multi-storied building was constructed on that site, my lord. And due to the construction of the multi-storied building, the distance between the naked 11 kV line and the building was at a bare minimum, which could be reached by a person, which is reachable, which should not have been, the distance was not, the appropriate distance which should have been kept was not kept, madam. On 27/07/2014, while the petitioner was playing with his friends, he went up the under construction building, and unfortunately, my lord, there was contact with the 11 kV line and he suffered burn injuries. And on 28/07/2014, he was shifted to Nemcare Hospital, Guwahati, because the hospital at Karbi Anglong could not treat his injuries, my lord. Thereafter, on 1/8/2014, he was shifted to Sir Gangaram Hospital, New Delhi. And on 30/8/2014, both his limbs, my lord, the upper limbs, were amputated from the arm's length, my lord, both the limbs. Now, my lord, lordship may kindly take up the writ petition. Well, I would like to show the liability of the PHE department.
Yes.
Lordship would take up annexure 32. My lord would take note, my lord, the date of incident is 27/07/2014.
Yes.
At page 32, my lords. My lord, it's dated 28/07/2014. The day after.
Page 32.
Page 32, my lord, annexure 5.
Yes.
It's addressed to the assistant executive engineer, dated 28/07. Sir, with reference to the above, I am to inform you that the 11 kV line, which is meant for additional chief engineer PHE complex, is in bad condition. So far, the construction of new office building is concerned. Therefore, you are requested to investigate the matter for taking measures and shift the line immediately to avoid any incident. Now, this letter was addressed to the APDCL a day after the incident had occurred, and there's no mention about the incident. And they are making a prayer to shift that 11 kV line, which should not have been there in the first place, my lord. My lord would take up the additional affidavit filed by the electrical inspector, my lord.
Yes.
And lordship may directly take up the report, which is at annexure 8, page number 3.
Electrical inspector is respondent number 9.
Yes, my lord.
Yes.
My lord, the 1, 2, 3 date, time, place, my lord, lordship would come. The second paragraph, my lord, page 3. As per the third paragraph, I'm sorry, my lord, as per the report furnished by the subdivisional engineer.
Yes.
As per the report furnished by the subdivisional engineer, SDE, Diffu Electrical Subdivision of APDCL, that a new building has been constructed by the authority of the Office of the Additional Chief Engineer, PHE Department, Karbi Anglong, under the 11 kV dedicated overhead line, of which the vertical clearance might be low, and the victim somehow came in contact with the 11 kV overhead bare conductor, and the said accident occurred. The SDE of APDCL also quoted in his report that the new building was constructed without informing the APDCL authority. On the other hand, the executive engineer, PHE DIFU division had submitted a letter to the assistant executive engineer ASEB, DIFU electrical subdivision on 23/2014 regarding the shifting of high tension line to a safer place as they were going to construct a new building in the complex of the office building of the additional chief engineer PHE department. Now it's marked in bold, my lord, the next line. The letter in issue was submitted by the executive engineer PHE himself on 14/12/2018 to this office. Although it is backdated, the report states it was submitted only on 14/12/2018, my lord, after more than 4 years, my lord, of the incident. Moreover, the additional chief engineer Karbi Anglong Autonomous Council Division, DIFU, wrote a letter to the assistant executive engineer AACB, number 1, DIFU Electrical Subdivision, on 28/7, the letter which I just referred to, my lord, from the writ petition, 28/07/2014, just after the day of the electrical incident in issue. The subject matter of the letter was that the 11 kV line was meant for additional chief engineer PHE complex, was in bad condition so far the construction of the new building was concerned, and requested the AACB authority to investigate the matter for shifting the said 11 kV line to avoid any incident. 11 causes leading to the accident. From the facts and circumstantial evidences, it is opined that the electrical accident was occurred due to the construction of the new office building under the 11 kV overhead bare conductor without maintaining the safety clearance or shifting of the line.
So whose responsibility was it to maintain the safety clearance?
Of course, now it was the responsibility of the PHE, my lord. Lordship would read the next paragraph, my lord. Had the PHE department constructed the new office building after shifting the 11 kV overhead line in issue, the instant accident would not have, would not have taken place. And had the PHE department constructed the new office building by maintaining the safety clearances from the 11 kV overhead line in the issue, the instant accident would not have taken place. Contravention from the facts and circumstances leading to the accident, it appears that there occurred violations of regulation 61 and 63(1) of central so-and-so. I'll place that regulation, my lord. On the part of the owner of the building, that is PHE. Recommendation, the provisions of so-and-so should be strictly complied with by all concerned to prevent such accident in the future. Now, what had happened, my lord? There was an existing Assam type house, my lord. At that point of time, the clearance was as per the statutory norms, my lord. Because they were constructing a multi-storied building by demolishing the Assam type house, they should have first informed the APDCL, shifted the line, and then proceeded with the construction, which was admittedly not done. My lord, to take up the regulations for a moment, which is there in the compilation, my lord. I have.
Yes.
My lord, at page 1 is the regulation, my lord.
Page 1.
Page 1.
Yes.
Regulation 1 states the name of the regulations, my lord. Next page, my lord, I have annexed the relevant portion. Regulation 61, my lord. At page number 2. Clearance from buildings of lines of voltage exceeding 650 volts. Ours was 11,000 volts, my lord, 11 kV.
Yes.
An overhead line shall not cross over an existing building as far as possible, and no building shall be constructed under an existing overhead line. This was clearly violated, my lord. Where an overhead line of voltage exceeding 650 volts passes above or adjacent to any building or part of a building, it shall have, on the basis of maximum sag, a vertical clearance above the highest part of the building immediately under such line of not less than My lord, we are concerned with 11 kV, my lord. It should be, the vertical clearance at one should be 3.7 meters. Had that been 3.7 meters, the 8-year-old child could have never reached it, my lord, from the building. Next page, my lord. It also speaks about the horizontal clearance. The horizontal clearance between the nearest conductor and any part of such building on the basis of the maximum deflection due to wind pressure should not be less than at Roman 2, my lord, 11 kV, 2 meters, my lord. Now, Lordship would take up regulation 63 at page 4, the other violation, my lord.
Yes.
Erection or alteration of buildings, structures, flood banks, and elevation of roads. If at any time subsequent to the erection of an overhead line, whether covered with insulating material or not, any person proposes to erect a new building or structure or flood bank, or to raise any road level, or to carry out any other type of work, whether permanent or temporary, or to make in or upon any building or structure or flood bank or road any permanent or temporary addition or alteration, he and the contractor whom he employs to carry out the erection, addition or alteration shall give intimation in writing of his intention to do so to the supplier or owner of the owner and to the electrical inspector, and shall furnish therewith a scale drawing showing the proposed building, structure, flood bank, road, or any addition or alteration or scaffolding thereof required during the construction. This regulation was clearly flouted, my lords. They should have first given the plan to the APDCL, and after shifting of the existing line, they should have proceeded with the construction work, which was admittedly not done. The letter of the additional executive engineer PHE would clearly disclose that, my lord, and the report as well. Now, it is apparent from the records that if liability has to be fastened, it is the PHE which is entirely liable for the incident. Now, had these norms, my lord, this 61 and 63, had it been followed, this unfortunate incident could have been avoided, my lord. So, insofar as the liability is concerned, the PHE is clearly liable. Now, coming to the legal aspect, my lord, insofar as liability is concerned, now APDCL may not be a party to the negligence, but since APDCL runs a hazardous business, and if anyone or any injury occurs due to the supply or transmission of electricity, the APDCL has to be made absolutely liable. So
but APDCL will say, how do we act unless we are informed?
Exactly. In that case, my lord, because APDCL cannot escape the liability in view of the constitutional bench judgment in Oleum Gas, which clearly says, my lord, if a hazardous business is carried out, any injury resulting from it would that company or that owner of the business would be liable. Now they have gone ahead from Rylands and Fletcher and developed the own liability, which is special to the Indian jurisprudence, my lord. Ryland and Fletcher had some exceptions. The court refused to follow those exceptions and come up with this new liability, which is absolute in nature. Now, in my humble submission, my lord, since the negligence on the part of PHE is, it's apparent, my lord, I would say, my lord, both APDCL and the PHE department is jointly and severally liable. Now, APDCL can always, can, if some compensation is paid, both are liable for the payment. They can always.
Who has paid this 4 lakh rupees?
APDCL under a scheme, my lord. Now, my lords, insofar as compensation is concerned, my lord, I'll place a judgment. It's a 2014 judgment of the Supreme Court.
So you tell her, are you seeking compensation in this?
My lords, I would answer that question, my lord. Insofar as compensation is concerned, my lord, because lordship, some monetary compensation would be necessary because the parents have already spent their savings, what they had on the child. Now, suppose the child outlives his parents, my lord. In normal circumstances, he would have. Now, if he outlives his parents, there's no one to take care of the child, my lord. Even now,
That is
his
exactly
16
why,
years-
that is the concern. That is why this matter has been kept.
Now, I've been told by his mother, he's now 16 years old and he's dropped out from school and he's under terrible depression because daily activities, my lord, like going to the washroom and everything, his mother has to accompany him, my lord. And so someone would always be required. For that, some monetary compensation would be required. And insofar as the rehabilitation is concerned, my lord, my learned friend referred to some schemes of the social welfare department. But for those schemes, my lord, in my humble understanding, is anyway, my lord, a judicial order need not be passed for that because he's entitled to those schemes, my lord. And I was told by the father of the petitioner that the chief engineer, additional chief engineer, they're willing to provide him a job if he has the power, of course, once he attains the age of majority, because only job he'll be
Grateful.
grateful. Even then, my lord, there'll be some sustenance, my lord. At least he can lead his life. And my lords, the concern of the parents now is the psychological imbalance what he's going through. And I've been told that he does not speak to anyone, not even his parents. And he's always in a state of. Now, I researched on that point, my lord. It's a very common syndrome and which leads to morbidity in most of the cases because of people losing limbs, my lord, amputation. So some psychological, my lord, treatment would also be necessary, my lord. Rest the judgments are, my lord, I have compiled the compilation, which has the topic and relevant pages are also mentioned, my lord. If your lordship desires, I'll place the judgments.
No, you have given it. You see, this is what I have mentioned in the first step also. These judgments are all to show whether they have a liability or not.
Right.
Let us assume that this aspect is settled. The question that would be that what is that you actually do which can realistically take care of the person? There, the court is seeking some assistance. What exactly?
Yes.
As you said, supposing his parents today or tomorrow are not there, how is he going to take care of his daily needs? What is the mechanism? Say he has 50 lakhs in the bank. Will it help? How will it help? And questions associated with that. That is what is crossing the mind of the court. This scheme, that scheme, all right, say he gets a job. That ensures that he will get some salary.
Yeah.
I don't think he will be able to do any work except maybe something which has got to do with just watching, sitting and watching somewhere, something. With the 2 legs gone, you can still survive. 2 hands gone, very difficult. So I really don't know how is he surviving, but if one visualizes a few things, it gives a very sad picture. That is why it would be very easy for the court to pass a judgment under 221, some principles here and there and say you pay this compensation. Compensation is required. It's not that, but should it be only a case of compensation or something more to it? That is where I was looking for a consensus. Where is the PHE council? Who is appearing for PHE?
Mr. J. Chutia was appearing in the first half.
Is standing council PHE?
Standing council. PHE. He's for Karbi Anglong, sir. The PHE department is.
Who is willing to give a job?
The Karbi Anglong PHE man.
What kind of job?
He will be only entitled to a grade 4, my lord.
No, grade 4 is
Chowkidar
fine, but grade 4 what job?
Chowkidar or a peon, my lord. Any of those.
Will it be of some help to the petitioner?
But that would, of course, at least future would be secured, my lord, a government job.
Hmm.
There'll be some monthly income, my lord.
Okay, apart from that, we can also think of some compensation.
Compensation, my lord.
And what about his sustenance, his physical requirements, sustenance, as you said,
My lord.
his day-to-day needs, including going to the washroom and other activities? What
My
about
lord,
that?
There are prosthetic arms, my lord, but Indian made, my lord, which are available at Jaipur or other government places.
So is there any prosthetic arm which at least-
There are, my lord, but it's very expensive, my lord. The German,
how expensive?
I'll take. Because the disability is 100%.
No, that's right. The idea is to see if something can be fitted to his,
Yes.
so that it gives him some mobility. Is there anything that you know? Anything? Or is it that nothing can be done?
I've been told, my lord, the place where the limbs are amputated, that is at the, my lord, arm's length. It starts from the arm, my lord. It's very short. So normally prosthetics would have worked. In fact, the father, my lord, he bought a prosthetic, my lord, arm for only 1 hand. 4 lakh, just 1 hand, my lord, 4,780,000. And the fitting charge was 1,79,500. It's from a company called Ottobock, my lord. It's perhaps a German company, my lord. So that will not work, my lord. I've been told.
That did not work.
Did not work, my lord. I have.
No, is there anything available in the market which works?
I have to come back.
That is what we want to know.
My lord, we already.
I'm not getting the answer.
Instruction is on the way, my lord. Give me a minute, my lord.
Instruction on the way means from whom?
My lord, my colleague is calling his father, my lord. Because already, my lord, this has been, this was the highest, my lord. What was done, it didn't work, my lord. So. My lord, it can only be fitted, my lord, after he completes 18 years, my lord, not now. Autobock, my lord, the same company, but it can be only fitted after he attains 18 years of age.
Then it will work.
Then it should, my lord, because when the father and the medical experts are also not sure, my lord, because as I submitted, my lord, the amputation, the level at which the arms are amputated, it's usually difficult, my lord. Had there been some of the arm left, my lord, the prosthetics would have worked, my lord, because of the, my lord, the nature of the amputation.
What is he trying to say? Yes.
The prosthetic limbs are, my lord, are a bit heavy. It can only be fitted after the boy
Bones
attains
have
the age of.
attained that density. That is why they do not, That must be one of the reasons why they're not being able to fit it with him. Because the density of the bones is not hard enough to take the weight of the prosthetic limb.
He has to attain at least 18 years of age, my lord.
But there's no surety that it'll work.
That no one can, there's no 100% guarantee. But mechanical prosthetics are available where there is movements in the elbows and
Movements are there.
movements are mechanical.
This is what electronic.
This was not
This is a
electronic.
prosthetic limb proper. That will be robotic arms, no? Robotic arms.
There can be
arm.
movements.
movements.
So what is there? We can ask the state government to bear the expenses, take his father and the patient to some place, get it fitted, bring him back,
That
give
would
him
be-
some
that would
counseling,
be-
put him to some job. These are the orders we were looking to.
Yes, yes.
But
my
you are
lord.
not giving us a clarity on what you are saying. There might be something, there might be something. Compensation, it cannot be astronomical, you see.
My lord, my lord,
For that, you have to go to the
I
civil
understand.
court.
I understand.
Where are the inputs are not coming?
My lord, if your lordship allows, my lord, sometime, my lord, I'll also, if your lordship allows, I'll ask the father to
That's
be.
what we are doing. Last 3 occasions, the matter has been adjourned on this.
I'll ask the father to be present also, my lord. And I'll also take these instructions because, my lord, I was told, my lord, they tried fitting a prosthetic, it didn't work, my lord.
So therefore, there is no chance of him. So we will not explore that angle.
No,
Is that
no,
correct?
that has to be.
No,
explored,
but
on
you
agreement,
either give us a clear answer or
Yes.
you have to look for someone to assist the court.
My lord.
I'm not getting the answer to these things. We have adjourned this matter twice. The idea was to see that the boy can be as self-dependent as is possible in this difficult circumstance.
My lord,
Money is not the only answer.
right, absolutely.
Money is required, but money cannot be the only answer. We are trying to suitably mold a relief for this person so that he can live a life without being over dependent on anybody. I'm not getting the inputs.
My lord,
You are only showing me law on Article 21. I have written 3-4 judgments on that.
It's there, my
I
lord.
will not read it. I don't want to see more law. What difference law will make in his life if he doesn't get something which is required?
I'll get back with the exact instructions, my lord.
Why the PHA council is not there?
I have found something on the net which says PO International, a company which is based in Gurgaon, Haryana, my lord. They have, the pictures show that the full hand is there. This, it's okay.
Mrs. Chaudhary, probably the member secretary, Assam State Legal Service Authority thought that the court has made a mistake by implementing Asalsa. That appears to be the nature of his.
Also, parameters they have said that in orders. They have to follow that.
Wanted some help for this young boy who's in a very, very pathetic condition.
It's really sad to say this, but also out of funds. No funds.
No, but who is asking Asalsa to do anything with fund?
Then
Fund the government will provide.
What kind of,
Asalsa could explore.
if you help in. They are by the parameters.
See, the Asalsa is because Asalsa has carried out some projects in Assam for fitting artificial limbs. I don't know whether you are aware of it. You are not aware. Maybe your member secretary is also not aware. There were some major camps held in various parts of the state where hundreds of people were fitted with artificial prosthetic limb. As a member of the High Court Legal Service, I had a role to play in organizing this. What happens is, I cannot call up someone today and ask for help. So I expected the Asalsa member secretary to inquire and find out if there is something authentic which can be done.
It was.
That is the reason why Asalsa was. Hmm. We are not asking Asalsa to pay money to anyone. So that briefing perhaps was not given to you.
In fact, my lords, the petitioner attended one of those
Just
camps. my lord.
1 second. If they cannot do it, maybe they'll be able to say what is there. Maybe something is available here, there, or can be brought from outside. If we are talking about a vibrant India, why should we not look into predicament of people like this young boy? Let us see if we can do something which can make him live a life, if not normal, something close to that. We'll have to adjourn it. And where is the PHA council? So you will appear.
I may bring council, my lord, as a PEC, my lord, public health engineering department, the transport subject, my lord, as the additional chief engineer under jurisdiction, my lord.
So he says the authority has offered a job, great for job.
I have some, I had already consulted with the my lord, secretary PAC of AR, my lord. And that my instruction is that at this moment, he is not in the under 18 years, my lord. So
That's it.
when he attains the age of 18 years, my lord, possibly, my lord, under that we have that quota, my lord, disability quota, is there, he can be accommodated like that.
Then why don't we put in, you
Well,
put in
yes,
affidavit?
we have affidavit, my lord, I can put. also
Then
there.
we can provide for
Yes,
it.
my lord. That future, my lord,
Respondent for-
employment, my lord, can take care of it. Total must come.
And as far as the compensation component is concerned, we'll ask the PHE
PSC
and
department, my
PPDCL
lord,
to
they have
share
to
it.
pay it, then we can only disperse, only it is a transfer, administrative control is with us, but funds should come with the government.
And we can probably request the social welfare department to
Yes, sir. It will be good, my lord. Then they
allocate
can-
some fund to see if the limbs are there. That was the whole idea.
Yes, my lord, that-
That was the whole idea. You want to live? Or continue in this case? You can continue to assist the court. Then we'll have it after 2 weeks or maybe in the new year,
New Year, man.
first week of. Heard Mr. P. Mohanto, learned counsel for the petitioner. Also heard Ms. R.S. Chaudhary, learned standing counsel Asalsa. Ms. S. Sharma, learned government advocate Assam, and Mr. J. Chaudhary, learned SC Kardian. Arguments have remained inconclusive. Let this read petition be listed again on 5th of January 2023 as a fixed item. In the meantime, subject to availability of the bench. In the meantime, the KAC may bring their stand on record by filing additional affidavit. Insofar as the proposal for giving employment to the victim on attaining the age of 18 years is concerned. Ms. Chaudhary, you can just find out from him, since Asalsa is engaged in this kind of project, maybe the member secretary can talk to them and see if there is something, some authentic.
Apologize, Lordship. Actually, I was not aware of the hearing was.
No, it's all right,
going
it's
on,
all right.
And I was not really aware of the parameters. why
That
I
is the
was-
reason why Asalsa was included.
I
To get
was not
some,
aware of that, therefore.
get some
Apologies,
genuine
Lordship.
this thing, and
I'll try. and
we
get
thought
back.
if necessary, if he is required to go somewhere and if a paralegal volunteer is required to be sent, we can probably
Provide
even
that.
look at that.
Right.
That's the reason. All right.
I'll look into it.
We'll get the precise instructions with regard to the prosthetics, my lord.
Yes, yes. Give us what is the prosthetic? What is the cost? Who gives it? What is the chances of it working? Concrete information with literature. We'll ask them to respond. And do it. Faster you do it, the better will it be for your.
Deeply obliged.
Deeply obliged. Within 50.
Hmm.
I have given a note, my lord. That's
Forgotten everything. This matter
Your lordship can pass the judgment. That may not, that seven.
today it will not be possible.
Today not possible.
Court is
But
rising
it
at.
can reserve for judgment also, why not? Because the
Not
parties have
possible.
been had.
I have to hear, they have not
and
yet argued.
Squarely covered by this decision, my lord. This is a constitution by judgment, seven by judgment. The school is in my lord, industry.
We'll take it up on 5th January. You can give, you have given a written note, no?
Written, yes, my lord.
What
That
about
is in
you?
the file, my lord.
Lordship will also file a written note.
File it in
And I
10
will-
minutes, 10
will be
minutes.
relying
you
on the
could-
cabinet decision that also I will provide. Because the scheme was formulated in pursuance to the
No,
cabinet decision.
her part she has argued,
Lordship,
but your part you have not yet
not
argued.
yet.
How much time will you take?
15-20 minutes.
By cabinet decision also it is covered. By cabinet decision also, Government of India, this is covered, my lord. The education is, my lord, entered in the scheme. They have included the education sector.
You
in
agree
the
with
scheme.
her submission?
No, Lordship, because we'll be differentiating with the
No,
cabinet.
it doesn't happen in 15-20 minutes.
It will
See,
take some
just
time.
20 minutes left.
Yes.
And these are matters with some financial implications.
Lordship.
So the court has to be very clear.
Lordship.
This is not compassionate
Now,
appointment.
now only for application, my lord. They have to be qualified for the apply. Hereafter
that-
again secondary, after registration, they have to apply again for the scheme. For financial implication. Now, my lord, no finance they are getting.
So they
They will
said
be
that educational
registration.
institutions will not.
No, Lordship,
Qualified.
in the sense, we are for only on those institutions which provides employment generation. That is the policy of the
165.
But why education does not provide
Lordship.
employment?
Vocational, we go for the vocational one, Lordship. Vocational training and all. That is what been stimulated in the cabinet decision, Lordship.
Hmm.
We'll be relying, we'll be
What is,
placing. the-
let's see, what is the question?
Lordship.
Have you got the copy of the
अपना
cabinet
copy लगी
decision?
बस। भाई तो अपना
Yeah,
copy लगी
yeah,
बस।
yeah.
क्या copy है इसमें? तो अपना दे दो। Lordship, the second page, Lordship. Which is here, na? Because schools comes under the service sector, Lordship.
But this is for tax concession.
Lordship, incentive for service sector, Lordship, page 20, Lordship. Under the secret, it's written secret, Lordship. No. अपना डेटी बोलो।
No, Mr. Chakraborty, you are referring to a circular of Ministry of Commerce and Industry, is it?
Yes, Lordship.
It
Lordship, may come
says
to page 17.
incentive for service and other sectors.
Lordship.
Incentive under NEI PP 2007 will be applicable to
To
the
the following service sector, activities, industry, service sector, hotels, so and so, medical and health services, free vocational training institutes such as Institute of Hotel Management, catering and food crafts, entrepreneurship, development, nursing and paramedical, civil aviation related training, fashion, designing, and industrial training. So school has not been included, normal, Lordship,
No,
education
but
institute.
this is not the exhaustive, exhaustive.
May not be, Lordship, but Lordship may come to page 17 also, the aims and statement of equity, and that is page 17, Lordship.
Page 17.
Lordship. Statement of equity, public and accountability and innovation. On the head equity, Lordship, it will promote an incentivize setting up of new industrial unit in the northeastern region by increasing the number of beneficiary units and will also generate large amount of employment. Then on innovation, point number 3, Lordship, The incentive proposed to scheme will promote industrialization of northeastern region by encouraging setting up of new industry unit in the region. In turn, will lead to larger employment generation. So employment generation being one of the primary object. Normal school doesn't lordship.
No, that is all right. First of all, this argument appears to be fallacious. Normal school does not generate employment. There are people working there, and the students someday will
come out. That will be a lot of larger.
But where is your statement that only employment generating institutions will be given the incentive? Where is that statement?
Page 40.
Lordship. Page 14, Lordship. Lordship is on the page 2 also. Lordship may come to page 2. Page 2.
Yes.
May read from the top, Lordship. The evaluation agency recommended inter alia that focus may be given on promotion micro, small and medium enterprises sector as they contribute in a big way to employment generation. Focus may be given to states of Nagaland, Manipur, Mizoram, Sikkim, which receive less benefit. States such as Assam, Meghalaya, and Tripura may be provided benefits under incentive and insurance scheme only rather than capital incentive also. Subsidized under NEIP may be limited to the investment of 10 crore or plant and machinery. NEPIP may be also be aligned with the national manufacturing policy, which will give more incentive result in promoting manufacturing, increasing employment and contributing more to the GDP. So all along being Lordship, the employment generation is the prime object, Lordship, behind this. Incentives.
I think he's reading from another scheme, my lord. That is NEIP is different and needs is different. Scheme itself is separate.
This is a different scheme.
No, Lordship. Lordship, the first page. Note for the cabinet, Lordship. From the first page, Lordship, say it is 2018. That meeting took place on 2018. The subject is needs. Subject to needs.
Any other education institution has been given?
No, we haven't considered any other.
Has any other education institution been given?
I don't know, my lord, that knowledge I don't have.
But
But my lord, department has forwarded. If the department manager, the function manager, GM, other, they have forwarded. The scheme. Only the, my lord,
They have forwarded does not give any right
Lordship,
to.
that is, that has been.
Not talking about the right, but my lord, that according to the guideline or my lord scheme,
Page 36.
they might have been, my lord, authorized to accept and my lord forward.
No,
Otherwise, the officials.
So please understand this.
Yes,
You will, that's why I'm saying. We are exercising jurisdiction under Article 226.
Yes, ma'am.
We are not the Ministry of Commerce.
Yes,
We will entertain, plea and adjudicate primarily on the touchstone of Article 14.
yes.
Discrimination. That look here, you have come up with a scheme. Their educational institutes, 10 of them, you have given them. And when I go there, you don't give me. So please listen, this will help you. Otherwise, I can close and give a judgment. That's not a problem.
Yes.
It's very easy to close it today, but you will not like it.
Yes.
That's why I'm telling. I'm trying to explore.
Yes, ma'am.
Prima facie, I don't think petitioners are entitled. And these are the reasons I'm making it clear so that if you can address the court and satisfy, I'm willing to consider. But the broad scheme on which these things are to be seen, this is something you have to know.
Yes, ma'am.
What is there in the mind of the court?
Only through RTI, we may be, my lord, get the knowledge, man. We have to file RTI, my lord.
No, it's not a question of RTA. Now they are saying that no educational institution which is not generating employment
Yes, ma'am.
is entitled under this scheme.
Yes, ma'am.
And the illustration they are giving is vocational training institution. They have named a few, saying that the whole idea of incentivizing these institutions or organizations is to prompt them to generate employment. If they generate employment, then there is a policy objective which is served, and therefore the incentive by the government.
Yes.
Because this incentive is public money. whatever government waives is again public money. So there has to be some nexus between the
Exactly, my lord.
object
Exactly, my lord. But my lord,
and what they are seeking to achieve. Now, that is why I am asking, is it a case that either in Assam or in some other place under the same scheme, they have given incentive to an educational institution like the one run by your client or any other institution which does not generate employment? If that is there and if the material is there, we will ask them why this discrimination. Correct.
discrimination.
Otherwise,
not
there
the
is
allegation
difficult.
here.
It is very difficult.
Discrimination is not the allegation here. My lord, definitely one student, he studied up to class 12 also. That is my lord employment generation because he can get a job for computer, my lord. Because all this computer class, computer training and different my lord education sectors, they can, if they are qualified, and definitely they can get any job and my lord.
Okay, now, would you like to come back on this or should I close it for judgment? Whatever you say, we'll do it.
Come back, my lord, we should,
No
because
problem.
earlier the lordship was in favor of me and because you see this judgment. In this judgment, my lord, the education sector, including the trust and everything, that has been my lord. declared
Education
as
sector
industry.
is service sector. We are going to write it in the judgment. It is
Yes,
service
ma'am.
sector.
It is a service. sector.
But
Exactly.
the
Whether the
But
scope can be
discrimination-
enlarged.
Discrimination education
scheme
I have not done.
envisages those in the service sector which is
Yes.
involved in employment generation. That is where the difference is.
Exactly.
That's why we are pointing it out so that you also can address
Just a
this.
few minutes I may be given, my lord, next day.
Yes,
Few minutes,
education
because
is service sector.
Education is, my lord, a service sector. Secondly, my
But
other.
that argument cannot be accepted.
Yes, my lord.
Just because education is service sector. Therefore, all service sectors rampantly has to be given benefit of this scheme. That argument 226 court cannot do it. Supposing the government does it and then makes a discrimination, then we can interpret the
No,
right.
The education sector, my lord, in the cabinet decision that has been included.
Yes, it
education
is service sector.
Yes, my lord.
Yes.
But earlier they disputed, my lord, the.
No,
cannot
education
be
is
an
service
industry,
sector.
this, that. Now, my lord, if your discrimination point, I have not got here, my lord, because we don't know that, my lord, whether anybody has received the, my lord, because other state also included, they have, anybody has received, my lord, the benefit of the scheme. And this application is
That
for
is
only for
the reason
registration.
I am saying
Registration.
case has to be made out because these are
Yes.
financial matters.
Exactly.
Just by passing an order will not do.
Yes, my lord, your lordship, can you give a date, my lord, so that I can satisfy your lordship?
You please examine this aspect.
Okay.
And you said the court was in favor. Even now I am saying education is service sector. But that by itself doesn't mean you will get a mandamus. There is no
Only for
policy document
application.
which
They are
says
only for applying, my lord, registration. They have refused to register. My lord, industry sector, they have registered, everything registered, but on the scheme, my lord, registration is necessary. They have refused to register me as, my lord, under needs. my lord,
that is
particular
because
scheme.
according to them, your client's institution is not entitled. Because it is not generating
GM has
employment.
forwarded the other authorities who are
No,
competent, they
that-
have
that will
been
not.
forwarded my case.
GM forwarding, GM's view doesn't bind the court. We are,
I'm not
Then-
talking about court. There must be something that my lord, the competent officer who has been entrusted with the duty. They have scrutinized and they have forwarded. Only the committee has rejected. Even the department has forwarded. Only the committee has
Lordship
rejected.
7.4.
So if there is nothing, my lord, the department would not have forwarded, my lord. That is my.
Page
submission, my lord.
37.4, Lordship.
many things happen in the lower level. We have to
Anyway, my
give
lord.
an answer
Yes, my lord.
on an interpretation of the,
Yes, my lord, the employment
yes,
generation.
because judgment by the
But
court
my lord,
is
the
precedent.
employment generation is there, my lord, because when I filed this, there are 165 employees. So employment generation is definitely there. But regarding other thing, my lord, that I'll again submit.
All right. So when would you want it? Tell us a
As
date
by your
convenient.
lordship convenient.
You seem to be a little disappointed. Don't be disappointed. There's nothing personal here.
Nothing personal, my lord. Your lordship can. Next week difficult. First week of, as your lordship said, 5th of January,
5th January.
because next week I'll be.
But please look into this aspect. I'm again repeating, you
Yes,
are
sir.
asking for a financial money decree here.
28 if possible, 20. 28 if possible.
20th of,
28th of December.
no, December not.
January. it will be something.
So for petitioner, so
Copy খন দিবা চোন।
CGC for the state. Let the matter be listed again on 5/1/2023 for further hearing. You please give a argument. Well, the propositions coming from the court doesn't mean it has been rejected.
Lordship. Exactly.
I'm putting it to her so that she can come very clear on this point. We will again test it. You can make your submissions, but prima facie, your argument is that those service sectors which are
Had
in
been
the job
identified.
of employment generation, even if it is an educational sector, will be entitled to incentive. And therefore, you have identified vocational training institutions. She is saying that educational institution is a service sector.
There is no doubt.
Because you have referred to service sector, you have to give me. And on the count of employment generation, she is referring to the employees in her institution, which obviously is not your point. You are about the output to society,
Outcome.
and she is about input in her institution. So obviously there is a complete divide on the way things are being looked. But prima facie input into own institution has nothing to do with this scheme. Why should government incentivize someone for running a school with your own employees?
Lordship.
That prima facie appears to be, yes. And also she's saying that school is a service sector. That also prima facie. the court
It's
is
also industry, that's also.
Yes. That is also correct. It is also an industry. But the only point is whether the notification is really meant only for employment generating industry. And if so, whether the school would come within that definition. And the second aspect is whether anybody which
It's a
is
matter
not
of right.
generating employment has been given the benefit of this scheme. If she can show that, you will have to
Any
give it to her.
discrimination has been done.
If she cannot show that, then the matter is different. Therefore, my opinion is the whole thing lies on these 2 points. Nothing more. We don't need to go for a lengthy hearing. 10 minutes is enough.
All right.
If you can address the court on these 2 issues,
Yes.
that is the key issue. And you give your answer.
Lordship.
If there is any material to show, you can bring it on